Yes.
If I may, Mr. Lawrence. Motion I have to mention hearing item number 22, Motion.
Yes.
Motion today, I have some difficulties, so if you may release it next week or Wednesday.
The request of Mr. K. Angami, the government has received the matters to adjourn to be listed on 9th of April 2025.
Motion item number 21 also, after 2 weeks, I've taken the consent of leave. Other party lawyer.
What is this matter about?
Is against
Acquittal.
Yes.
No, I don't have a case.
Okay.
You don't have a case. Acquittal against acquittal, what is that?
Okay, now he was convicted under section 304. Now is it preferring for enhancing the sentence to either to life imprisonment or for conviction under 302.
So this I will adjourn it for a long time. We'll have it in the month of May. Month of May when the weather becomes more warmer. Okay. At the request of Mr. K. Angami, the matters can be adjourned to be listed on 21st of May 2025.
Hey, Mr. Lordships. Lordships, this writ April 27, 2024 has been fixed for today.
Okay.
On 18/3/2025. However, it was not listed today, so last night I was informed by the registry to kindly mention it so that they could bring out a supplementary list.
Against my judgment. Okay, it is against my judgment.
It's not, Lordship, it's against my Lordship Justice Chowdhury's judgment, not my Lord's judgment.
But he has,
Just that,
he has followed my judgment.
that has been referred, Lordship.
No, did he follow my judgment? Referred is different. But he reliable.
88, paragraph 4 and 5 of the adjournment. Page 388. Paragraph 4 and 5.
You make a mention next week. There might be a change of the judges.
Lordship. Obliged, Lordship.
Resolution of mention item number 29. Received the affidavit filed by the appellant who is mine.
What is the affidavit? Affidavit in a writ appeal?
On the application, this court has directed the state government, the appellant, to make its clarification as to whether the OEM would override the statutory rules. Your Honor.
Which one? Which one?
The Nagaland,
Which OM?
it's a different, it's regarding the pension, the enhancement of pension.
So you filed an affidavit there
Yes, I've already filed the affidavit, Lordship.
and he wants time.
The Nagaland service, RP rules 2010, Your Lordship.
Okay, you have urgency in the matter? You have urgency in the matter?
Your Lordship, if my friend is there.
Mr. So-and-so appearing on behalf of the respondent numbers 2 and 3. 2 and 3? Respondent number 1 submits that the affidavit, that an affidavit has been filed by the state of Nagaland clarifying its stand pursuant to the order passed by this court. He has received the copy of the affidavit only today. Taking into account, he therefore seeks for an accommodation. List the matter again on 9th of April 2025. Mr. So-and-so appears on behalf of the respondent number 2 and 3. Yes.
Lordship, I'd like to mention item number 17, Lordship. Lordship, if this matter can come up after 2 weeks. I have taken the consent of the parties.
You are inside?
Lord,
Right.
item 17, Lordship.
You are inside or outside? This person, is he in custody or outside?
In the custody, undergoing the.
Then why you are asking for an adjournment?
Since I have other method for having, so it
So-
can come out of the.
So for you, this person's liberty is not the question. How can you ask for an adjournment when a person is inside? Tell me.
Lordship, I have some personal difficulty today, Lordship. If this matter can come out next week, Lordship. Lordship, if you can take it up right next week.
You are for the, oh, he is for the
I'm for
people.
adjournment.
Oh, that is why he is asking for adjournment.
Yes,
You have no urgency.
no, we have urgency, but he has difficulty today, so
I have difficulty with this, Lordship.
Okay, at the request of Mr. V.G. Momi, the learned counsel appearing on behalf of the learned PP, Nagaland, the matter stands adjourned to be listed on 9th of April 2025. Mr. So-and-so appearing on behalf of the appellant expresses extreme urgency.
Lordship, I also like to mention item number 4, Lordship. I will be filing my PPT.
No. These matters will take up when the matter is there. Don't seek an adjournment at this stage for motion or admissions, anything.
Lordship,
Hearing, I will take care of it, but the other matters we'll see when. the matter-
Lordship, since I have obtained the.
Mr. Counsel, you have no other matter today in any other court. Because this is the only court sitting. So wait for your turn. See, we'll see. Don't mention all this. Any hearing matters with adjourned, it's okay. But others will see when the matter reaches. Thank you.
Yes, that's good.
Please, your Lordship. Lordship, I'd like to mention hearing item 16, Lordship. Lordship, it is, let it kindly come about there, week, Lordship.
Why?
Lordship, here we argue consider is currently out of patient to conduct one criminal matter in the court, Lordship.
Well, in this regard, similar situation. The Fagilish is also pending the page for special petition. So that
Matter pertains to what? Matter pertains to what?
census, population census part.
Hmm?
Population census.
Oh,
Lordship.
So you wanted how much? How much is adjournment?
Lordship, next. Maybe listed up after a week, Lordship.
My lord, we had submits,
It's okay. Is the similar issue pending before the apex court?
Lordship.
Then we can. You can have it after 2-3 weeks, taking into account, but I would not refer that the matter is pending before the apex court, taking into account that when there is no stay, it would not be proper on the part of the court. It has been submitted by the learned counsel appearing on behalf of the appellant that some accommodation is required. As the counsel who was to argue the matter is indisposed. So taking into account the above, this matter on 16th of April 2025.
What's the first?
For admission, item number 1.
Yes, Mr. Takamasu, what is this matter about?
For Lordship, the Dimapur Kohima issue, road. It is still pending.
But while coming yesterday, there seems to be some improvement.
Yes.
Last December.
At least, it is bearing fruit, Lordship. It is bearing fruit. This year is bearing fruit.
Except that landslide area.
Yes,
which-
that also will be, that falls within the jurisdiction of the state government, Lordship.
Okay.
So that issue also will be, dealt with today. Certain direction has been issued and some compliance is also there. Lordship, may kindly allow me to refer to the last order passed on 12 March 2025. And under the basis of this order, Lordship, some direction can be issued after reviewing the order.
Yes,
May I have it, Lordship?
yes,
My lord, I'm looking from paragraph 2.
yes.
In Kapla Pahar area, GH1 26 was washed away by flood waters. In course of previous deliberation, it emerged the river bank was required to be expanded to prevent similar recurrence of similar events. The NHMTCM had expressed a view that the river bank would be required to be expanded, and for that purpose, acquisition of land would be necessary for hill cutting. The Commissioner Kohima was asked to file an affidavit regarding the steps taken for acquiring land for expansion of the river bank at GNH 126. In deference to the above, the Deputy Commissioner Kohima has filed an affidavit on 6/3/2025. As per the said affidavit for acquisition of land at GNH 126 at Bakla Bahar for expansion of the river bank, a joint verification was conducted along with the concerned officials of various departments, including the NHIDCL, village council members, and the contractor. On verification, it is been ascertained that the area measuring 34,285 square feet has been affected for a proper flow of the river, and assessment was worked out pertaining to the acquisition of the land in the accidental damage. It is stated that the verification report has been forwarded to Commissioner Nagarjun Kohima on 10 February 25 of further action. As rainy season is approaching, additional Advocate General shall this instruction will record the action taken and the report of the Commissioner Kohima by the commissioners was to complete the process of acquisition and installation of the river bank before the rainy season and the next day the rain. So, my lord, for this, let additional AG, my lord, give a his instruction with regard to paragraph 2, 3, 4, and 5. Thereafter, Lordship, kindly allow me to continue with paragraph 6 thereafter so that we can pass orders.
Now, as I could see, it's a very lengthy order. The issue are in 4 parts. I think
Yes.
4 or 5 parts. One is as regards acquisition.
Yes,
There was a joint survey being made
Yes.
with the NSDCL authority.
yes,
And what is the progress as regards the acquisition?
Yes.
There seems to be one.
That, let, Lordship, if we can tell point by point.
Point.
So my respectful submission is, I'm sure, let the, since direction was issued the additional AG to give instruction, to receive instruction on this point from the commissioner, what is the progress? Because Lordship, once the rain starts,
Yes.
it will be difficult for the health cutting.
Because in paragraph number 5, this was the issue which had been reflected. And the
Yes.
rainy season is approaching, so and so shall place instruction
Yes.
with the action.
Yes, by Indigenous, it has to be, it has to be cut by this month. Otherwise, by next month, it will be difficult.
Now, Mr. Takama sir, one thing, there are two aspects.
Okay.
One is clearing of debris or acquisition, but the acquisition, once the joint survey is being made,
Yes, Lord.
they can very well go ahead with the acquisition. What is required to be done after acquiring the land by the authorities is another aspect.
But
But
therefore,
therefore-
instruction be already, the direction be issued so that they can go ahead with the
So
work.
therefore, they should go ahead. If they have,
Yes.
they have already on the affidavit of the deputy commissioner, it says that around 34,000 some square feet is area is required to be acquired.
Yes,
So if it is required, they should go ahead with the acquisition
my lord,
because they have already made the survey.
exactly, Lord.
Because if I understand
And it
correctly,
appears, then most of the land belongs to department. Some
they will,
department.
you will be acquiring under the Nagaland Acquisition and Requisition Act. So if that be so, they will be following the Land Acquisition Act.
Lordship.
So in Land Acquisition Act, if it is follows, section 4 says that the survey is to be done immediately after the, what you call, the notification is to be issued. So there is notification. Have you issued this under section 6?
My lord, the process,
Have you issued that notification?
Yeah, we have done all the spot verification measurement was done and
But
assessment.
Mr. Imsong, isn't
Yes.
the verification survey, all these things
Yes.
are done subsequently? First, you see, there are one thing on the ground you have to do something, and one another thing is that you are going have to do on papers. The paper thing is for going for a notification. Then making thereafter, after the notification, you are to therefore adjust as to how much area of land you have required and then pass an award. Because you will be following 6 and 9 of that particular act. So therefore, you are to therefore issue that notification. So what is stopping you from issuing that notification?
So the deputy commissioner, they have submitted all those spot verification.
Because you
assessment
cannot
and-
clear, you
Yes.
cannot use clearance of that land. You see, the rainy season question will only come
Yes.
in when after acquisition, which you will have to do by expressing your or by invoking your urgency provisions. Once you take over the land, thereupon the question will arise as to how you are going to take over and do whatever it is necessary. But if you are delaying it, obviously you cannot do without an acquisition process being initiated, you cannot. So therefore, the question is whether you have started the acquisition process. No.
No, no.
Lordship, my respectful submission, if Lordship may give us proper direction within a time frame so that it will be done before the rainy season.
No, rainy season is another aspect.
Yes.
Rainy is on ground.
Yes.
We are concerned on papers, what you are doing, we have not done anything.
Like a process.
Then you should do it as urgently as possible and then take over the land by invoking the urgent provisions. If you are not doing it, then once you take over the land, the possession, then only the rainy season will come in. The question will come in as regards it. Because unless you start the initial process, it will not happen. So this is the first issue. Now let's come to the second as regards the
Secondly, Lordship, let us read from paragraph 6.
yes. Now this is as regards the debris.
Yes, but debris has been cleared so far.
It has not been cleared.
It has been cleared, 50 months, Lordship.
From the carriageway, from, we are going for a construction of a bus stop.
You mentioned.
You are Mr. George.
Yes, sir.
Last time you were therefore asked to place and explain the up-to-date status as regards the works of clearance.
Yes,
Now it has been done.
yes, the debris from the carriageway is completely cleared.
Okay.
Now we are planning for a reservoir construction over there for that, protection part, so that additional will not hold on.
So that has already been done.
Yes,
Any affidavit has been filed in that regard? No.
no, we will get.
My lord,
And
this statement.
Mr. Takame, sir, you are the amicus.
Lordship,
You also have stated that, have you visited that area?
Monday,
Monday.
yes.
Okay. So for, as
Yes.
per you also. it is.
Yes, I have.
This area is which one? The area?
Kohima area,
Okay,
right after, Kohima, but before reaching Kohima, right after Tasmania.
okay. So on the left hand
Yeah,
side.
the
there-
first village on the
Yes.
left hand side of it, yes. It is still closed, that area is still closed, but it is closed, we have to remove. It
And
is
what
closed.
about the debris just after crossing nearby to Dimapur that has been removed? The debris which.
No, that is removed, that is the one. That is.
That is the one you are saying.
Yes, doctor, that is the one. He is already removed, doctor. Debris has been removed. Then Malad,
Yesterday I came a bit late at night, so I didn't watch
yeah,
it.
that
I
is.
didn't have a look at it.
The 2 lane is still closed for completion of the protection work in that Kohima other area, there was some slide. The
Yes,
protection, returning wall work is going on there. So
okay.
the 2 lane is still closed, but the debris is removed from the carriage way.
Okay, so this is the second issue done. So
Yes.
what about the third?
Malad, paragraph 11 and 12, this is also cleared.
Yes.
Done. So I'm reading from paragraph 13 also, Lordship, it is.
It is already mentioned by
Yes,
Mr. Seki.
Malad, I'm reading from paragraph 19. Mr. Chairman, the council representing the respondent number 19 has strong intention to the court to the statements made in paragraph 4 of the state affidavit wherein respondent number 9 has undertaken to complete the project titled short-term maintenance contract for scaling of hill slope and installation of rock fall area in Baklahar, Dimapur from such and such to such and such percentage rate and work basis, the slope construction in short on or before 31/5/2015 and submitted the works are being carried out presently. Mr. Jamir has further submitted an India the affirmance made in affidavit of respondent number 16. There appears a necessity on the part of the respondent number 19 to traverse those conditions by way of the joint affidavit in discuss.
So they have given an undertaking that by 31
That
5 they will
affidavit is fine. But only there is a reason regarding Village 164, the big landslide, because of that. There, my little friend was supposed to file a rejoinder affidavit. To settle.
Yes, Mr. Jamir, you were give an
Yes.
update. Huh?
The Lordship, response number 19
Hmm.
has been given the contract for installation of rockfall barriers and also for slope prevention wall. Now, so first, regarding the rockfall barrier installation, I have given the affidavit giving the assurance undertaking that it will be completed by 31st May. Now, regarding the other, your worship, slope prevention. Now, in that, your worship, the response number 16 has got an affidavit, that is the NHITCL Executive Director, to which I have sought time to be extended to file a joint draft affidavit, your worship. Well, actually, your worship, the joint draft affidavit, we really got some messages from the petition correction is to be made, your worship. So I feel that I will be given 2 weeks to just sign the worship. To file a joint draft affidavit.
Mr. Jamir, we are out here only monitoring. We are not saying anything, what is to be done, how is to be done, we are
No,
not.
sir.
What we are doing is monitoring in view of the fact that it has taken more than 2 decades, no, to complete this construction. So you have given an undertaking that you will complete your work by 31st of May 2025.
Yes.
Now, on the last occasion, as I could see from paragraph number 20, Mr. Takamasa had submitted that in view of the undertaking given by the respondent number 19 in the affidavit to complete the slope construction on or so and so, the court may await to know about the progress till the next date of listing.
Lordship.
So thereupon, have you mentioned anything as regards the progress out there by filing any affidavit to that effect?
No. Now, that part installation of rockfall barrier, that chapter that can be opened if the work is not completed by 31st of May, your worship. But I'm on the other contract, your worship.
Which one?
That slope protection.
Okay.
Slope protection. In that, your worship, I am to execute with slope location for your worship in 16 locations. 15 locations, there is no issue as of date, works are in progress, your worship. But there is one location regarding in respect of change 164, is your worship may recollect last year in the month of August, there was a massive landslide, your worship. And because of the landslide, your worship, the whole area, this total change in this. So as per the original design, it cannot be worked out, your worship. So in that condition, your worship, I have said, okay, reach out there. So the 2 weeks time which I have paid your worship. So I feel that for the time, 2 weeks time, maybe pay your worship. If I reach that. That is the other way, your worship.
Now, what about that Bailey Bridge?
But it is, the regard is common in the 15 years.
The Mojo is there.
Yes, worship.
The bridge looks like the same from 2021.
No, we have to work on the first March. The materials has arrived, worship. Because the work was undertaken by a different contractor before. Now we have to contact the contractor and then take assessment of what the requirement is, worship. And we have ordered the materials. It has reached. And we have started to work on 21st March. Recently, worship.
So now there are various different contractors being given different works.
No, worship, under the package 3.
Because earlier, when I used to take up this matter with Justice Sato, then in Denver, there were 3 parts.
Yes,
The part 1 was done by one contractor, 99% was almost complete. Part 2 was done by some other contractor, package 1, and the third was the main problem, which was the issue everywhere.
Yes.
There was certain imposition of cost of something, the imposition of penalty of some huge amounts which were there. Matter went to Supreme Court, and after that, it was being taken up by the principal seat after Justice Sato retired. And then now the matter has come back after the Supreme Court must have decided that issue.
Yes.
Now, in these 3 contracts which is being given, because earlier there was only one contractor who was given the Chinese 3, the package 3.
Yes.
Now there seems to be different contractors, or it's the same?
Not for slope management. New contracts has been, new TPR and new contracts have been issued for slope management and to control the rock falling.
So this is a different contract.
Yes, different.
So that is one.
Other than the normal roof construction.
And one for clearing of the debris is another contractor?
But that is part of the initiatives here. Yes.
Yes, you are the best person.
The package 1 and 2 was constructed by a contractor EZI. They completed that project. Package 1 is not at completion is not at issue, and package 2 is under maintenance. Package 3 was recently awarded to last year awarded to for the number 50 brand deals. Now they are doing the construction of the package 3. The other works, and one is slope protection, which we have awarded to McCaffrey Infrastructure Private Limited. They are doing the slope protection in package 3 and package 1 area.
So this is a different contract.
That's a different contract.
Which had nothing to do.
Yes.
Nothing to do with the construction of the
road construction is entirely responsibility in package 3. Package 1 and 2 are under the maintenance. And for small work, we are giving another small contractors like site clearance and other works.
Okay.
Protection work, river protection work. That's why the works are being awarded to different contractors.
So overall, you are in charge.
For these 3 packages,
No, NHIDCL is overall in charge of everything.
NHIDCL is in charge, sir, and I am working with.
So you are to therefore see as to whether the work has been done or not.
Yes, sir.
I hope it doesn't take more than a Taj Mahal.
Then Lordship paragraph 24, 25 and 26.
Yeah.
On such and such, was submitted and Gauhati responded on the 15th that construction of the bridge in Chennai 165 had already started. Mr. Church had submitted it on inspection. It is found that foundation works for the bridge are already completed.
But this is another bridge.
Yes.
That is not the Bailey Bridge.
No, the Zubza bridge, the first bridge, the last bridge was Kohima.
So the bridge after crossing Fifemia,
Yes.
you get the first bridge. That is a longer one.
Yes.
That's the Bailey one.
Yes.
And which is the second one?
This is the first bridge that we
From here.
Yes, well going from Kohima.
Okay.
In the river. It was submitted on behalf of respondent level 15, the construction of the bridge at Chinoch 165 that already started. Mr. Church has submitted, but on inspection, it is found the foundation works for the bridge are already complete and substructure work of the bridge is presently being executed. Mr. Mozoe has sought to expand the file and affidavit to apprise about the status at the bridge at Chinoch 165.
So, Lordship, I filed my affidavit, Lordship, yesterday. Now, in my paragraph 4, I've already stated, Lordship, the work has started, Lordship. But towards the opposite, there's some land order issue. Because there are some shops. So the landowner has stopped the work, which we are dealing locally. But now the integration of the administration is required, Lordship, because they are stopping the work towards the opposite. Kohima side is clear, but the opposite, Lordship, we have stated in our paragraph 4. Now we are having some issue with the landowners. The landowner is claiming that he has not been compensated, which we are dealing with them locally also, but which is beyond our.
No, has not been compensated means have you acquired the land?
So, Lordship, that government has to. Because for us to work was.
Because you cannot construct unless the land has been acquired if it belongs to somebody.
Sorry, I'm not sure. So,
Lordship, in fact, we have written the letter to the.
But why, after such a long time, you have not given up the clear right of way till now, Mr. Imsong? Why it has not yet been given? The right of way has not been given. No, this is not a new area being constructed. The area constructed was already, the area has already been demarcated that this road will go like this, there will be these bridges which will be there. This was a part of the contract which was given to another person at one point of time. Then he was terminated, a new person was appointed. Now this is the third person or fourth person who have been appointed. So the fact that where the construction is to be carried out is already there. Then how can there be a problem at this end of the day when these particular construction work means how can there be a objection by anybody as regards the right of way? And if he's saying that there is a problem, have you written it to the authorities?
Yes, Lordship.
Then what is the
Lordship, we have drawn the attention of the NHIDCL. Now, NHIDCL has written a letter to the Deputy Commissioner with regard to this issue. That was written on.
was it not acquired, Mr. George? Was it not acquired, this land?
Sir, as per our reports, it was already acquired and the all compensations were paid. But the locals are claiming they didn't get it. One or two persons, they are claiming that they didn't get the proper compensation.
If they don't get it, they are to therefore approach the court of law. They cannot disturb it if the land has been acquired.
That's why we have written to DC Kohima. Administration had made some visits, but the matter is still not solved. So
But how are they, after the land has been acquired, means the possession must have been taken. Then how are they constructing shops out there? How is it possible, Mr. Imsong?
no, super, actually, when the area comes under ROW, so the landowner has no right to disturb.
Absolutely no.
Then,
If the land has been acquired, if he has not got compensation,
Yes.
he will get the compensation.
you also here, the street between the Kohima and the Buffalo is a very unique road. So that particular area was acquired, which comes within the bureau of the ROW. But because of this geographical account, landslide, this and that, it comes.
So have you changed the area?
No.
It remains the same. So if it remains the same, where is the question of any person disturbing? If he has any problem, he can very well avail remedies under law.
May I address you, Lordship?
Yes.
My respectful submission is that it appears the deputy commissioner has needed to decide, but if a type of direction is given to the deputy commissioner Kohima to solve the issue, because it has to be, foundation has to be completed before the
Yes.
rain.
No, therefore, the question is, once the land has been acquired
Yes.
and the possession have initially been taken or not,
Lordship, maybe there must be multiple landowners, maybe some are.
No, somebody has
Receive
not-
receive all this, some that can be sorted out the administration, Lordship.
so somebody has not got the compensation, let him go and approach the court.
Yes.
So one has to advise it in that regard that he has to file reference case so before the court. Or say that I have not been given the possession, I have not been given the compensation. But he cannot later, he cannot disturb the possession of anybody.
Because mostly for us, if there's no obstruction from the landowner, we have to complete by 4 months. Within 4 months, we will complete it. We have already given a statement of in our affidavit. We can complete it, but the only obstruction is towards the Dimapur side, not the Kohima side, the bridge, the Dimapur.
Mr. Mojue, all contractors always first come up and gives an undertaking and then creates a thin small thorn out there. By the time when the 4 months is about to reach, this thorn becomes it becomes very difficult later.
I'm not
to-
surprised.
This is how it happens
Lordship,
at the end
as
of
per
the day.
progress the work, Lordship. We are beyond the milestone. We are beyond the milestone.
No, very good. We are very happy for that.
Lordship.
But the only thing is, this is how thorns are being created. But you have to take care of it.
Yes, the administration.
We
has-
pass a direction. If the land has been acquired, the deputy commissioner has to take up action. And the state has the police power, they have to take action against whatever may be. If that person has any grievance, he can very well approach the authorities, the court. This is how the things work. Because you see, as per the moment somebody causes any disturbance in respect to the execution of any order by the authorities concerned, they can be booked under the provisions of the Act, the BNS.
Yes.
Once it is being done, things will move.
May I read from paragraph 27, Lordship?
Yes,
We continue.
please.
Ms. Amicus Curie has drawn attention to the issue of sinking area at GNH 164, because there is a big landslide.
That's
In
the
response-
The lane landslide.
landslide area.
Yes.
Yeah, the
Last-
lane
last
sinking.
thing.
In response, Mr. Mozoe, counsel for respondent number 15, has submitted a chief technical report as indicated in the order dated such and such has already been submitted. Unqueried, Mr. Church has submitted that design in respect of file foundation work is also required to be submitted by respondent number 15 as the contract. In order to execute the work at change 165 for example, the design is required to be submitted along with geotechnical report. Respondent number 15 shall make all endeavors to submit the design with regard to file foundation work at change 164 as observed in NHIDCL within a period of 2 weeks so that NHIDCL can give consideration to wait for according its approval. MAK's Curie has further drawn attention to more issue of construction of National Highway Road Package 3 as all the above mentioned works are ancillary to the National Highway Project. As well as Mosaic learned counsel for respondent number 2, who is contractor in respect of the one of that will be the next issue. Has submitted the progress of the work so far is 50%, which Church in Mosaic has submitted progress made in all plans will be brought by way of affidavit within 2 weeks. This court is of the with such affidavit should be accompanied by bar chart of progress. So one that has affidavit is fine. But with regard to the file foundation, the geotechnical report, whether that has been approved or what is the status? With regard to the sink file foundation at the sinking area logic.
So 12.64, this package 2 is in bad shape.
Which one, Roger? Yes, that is the last, we will come to the last stage, that is the pumping area, Roger, which option is mentioned after Kohima bypass. That falls within the state restriction. So I'll come to this issue, Roger. Lastly. But before that, we can complete the 14, Roger.
Yes.
In my paragraph 5, Lordship of my affidavit, clearly stated regarding the submission of the geotechnical report, Lordship. And here we are having some problem with the landowner again.
Okay, so this is 12.64 kilometers where you have to just bifurcate out here. It means there are some roads which have not been yet been
Yes.
made.
the-
So there are
that's-
certain hills and by the side of
Yes,
which where
yes,
you
that
have to
portion.
come.
Before the river.
Now they have done, the work has been done.
Malo, there some work has been done, but then last time I submitted to control the sinking area, pile foundation has to be installed below the road. so that the massive landslide, because there is water flow also there. So that in that view of the matter, Lordship, on the last occasion, the direction was for the contractor to submit geotechnical report. So that the sinking area can be protected.
But tell me, how will this court look into those technical aspects?
My lord, the technical report has to be approved by the.
So therefore, I see from that order itself that they are going to submit the report within 2 days, within 2 weeks to the NHIDCL. And the NHIDCL was required to approve it. If
So
it
that's
is,
part only, that much only, Lordship.
yes.
So that has been done on that.
Yes.
Allow me to explain it further. Because in that road, that particular area is sinking, there is some problem with the road because of the landslide issues. So there are two proposals. One is to make a permanent solution. For that, the contractor has submitted that a viaduct, a kind of bridge, elevated bridge will be a permanent solution. For that, the design, a kind of initial general alignment going and the initial geotechnical going to be subject to us, which is under our review and some certain, we need some more details. That is going on one side. It may take some more time to finalize what is the proper solution because it has to take an additional approval from your quarters and all.
I think the expenditure cost will be.
Yes,
there.
yes. That'll be good. But at the same time, for this season and coming, maybe for the bridge also construction will take another 2 years. So before that, till that time, what we propose is we immediately ask them to construct the breastwork with the burden as a protection for the immediate sliding. Then there are 2 culverts which are adjacent to the particular landscape area. Those are small. So we suggested advised them to do another culvert, which is of 3 by 3 size, bigger size, in the same in the location. We can explain it with the photograph.
Oh, this area. Ah. This area, they have done some blacktopping.
Yes,
Yes.
full lining,
Four laning is the straight way. Four laning is actually the street.
Four lining will
Straight way.
Yeah.
And
Four
then
lining
you
will
are
go.
taking I think, the detour by the side of it. You are having a 2 lane.
Yes.
So,
So the
you see,
current issue, sir, for this, once we started the culvert excavation and PCC, locals objected there also. People from downstairs, I mean, downside the valley, they are saying that the water will go to their paddy field and they didn't allow us to, they are not allowing us to complete the construction. We took up the matter with DC Kohima. There was a joint inspection, but the matter is not yet sorted out. My submission is please give some direction for making it as early as possible because before this monsoon season, we have to complete the project. Otherwise, the road will be fully affected. In case further side is coming, the water flow will be too high. During the monsoon season, it will be very risky again.
Not sure here, the Mr. Client is supposed to maintain the slope so that the water will be diverted from the top. But then in view of the technical issues, where we have prayed for and finding a reply after it. That is why the diversion of the water has been delayed. In the meantime, they are coming with this suggestion for construction of a third culvert, but it appears here also the district administration has to intervene to ensure that the land issues at the moment. And my lord, before the rainy season, this has to be completed, otherwise again the slide may occur. So my lord, my respectful submission.
now, if some people are affected
Yes,
on account of this water
lordship.
sliding, this culvert being made, they are to be compensated.
My lord, for that purpose, let the deputy government, state government.
The state government has to take some
Yes,
call on that.
Yes, lordship.
But for that, you can't wait for another 1 year.
No,
Means how many years will it take? yes, this is the solution. Yes, there might be a reason how it is. You are to take some action on that. We cannot also allow you to take anything, any rights of the land of somebody by way of force. That would be in violation of the Article 300A. So you are to take some call on this if it is required. Who is going to pay the compensation? The NHIDCL is going to pay the compensation, isn't it? No, if any land is being acquired or anything happens,
Yes.
it is the NHIDCL who is going to do.
Yeah.
And why you are not taking any steps on that regard? But if that is another thing, Mr. George, is this: tomorrow, because of your action, you may have taken a land which falls within the acquired area. Very well. But if after the acquisition, if somebody else is being affected by something, then some compensation has to be paid to those persons because their right of use of the land of that has become affected. That is one of the parameters which are there in Section 27 of the Right to Fair Compensation Act. So they have to do it. So you have also to take it up with these authorities. You cannot just say that they have not allowed me to go ahead, so kindly do it. Because the moment that they do something out there, it will definitely affect the rights of those persons whose lands would be affected. So how do you take care of the situation? You have to tell them, okay, do something. If any compensation is required, we will have to disburse it. But something has to be done in that regard.
But that point, we have immediately requested the DC to involve and accordingly a joint visit was conducted. But the matter is, it was only a discussion. The matter is, no final direction was given by the DC also to like do it like that.
Because you have also to know what is the concrete proposal. You have to also put it up to your authorities.
Yes, of course.
That what is the proposal, what is going to be the affected area. Why don't you, have you negotiated or talked to these people as regards what is the effect they are going to have? Have a meeting, discussion with them, and take it and bring it to a logical conclusion. Obviously, you are not going to pay them something which is going to be phenomenal. They will ask. That's a different thing. The moment the people come to know that there is a culvert which has to be made, and it is compulsion. So therefore, we are going to cause a problem till we don't get what we want. Maybe reasonable or unreasonable, that is what they will be asking. So the state has to take some action to that effect.
Malo, this has to be given priority because it's a time-bound work. If not done, the whole thing will be repeated again, the problem that we faced last year because food is sinking every day. Then noted from paragraph 33. The total length of Dimapur is 56 kilometers approx. The Ministry of Road Transport has entrusted the NHIDCL with the construction of National Road number 29 for a length of 43 kilometers through package 1, 2, 3. The road stretch of NH29 outside the package 1, 2, 3, that is 12.4 kilometers, which is from GNH 172.9 Chutsuma bypass to 185.540 Liri Gate. And the said stretch is within the jurisdiction of the Public Works Department. Has submitted that the condition of stretch 12 of 1 to 12.64 is deplorable on 22/1/2025 in Song additional AG on the basis of a letter bearing 21/1/2025 of the Chief Engineer PWD National Highway, Kohima has submitted that after grant of sanction for special repair by MOD, Government of India special repair for reconstruction of the protection works, clearance of landslides and restoration of damaged stretch with non-bituminous items of work was sanctioned and a work order was issued in favor of contractor MS Goengra Enterprise, respondent number 20 on 6/12/2024 with the schedule period of completion of 3 months. Taking note of the conditions, wherein amicus carry that the said stretch of work is still in deplorable condition, the execution of work was completely completed within a period of 3 months. That is from 16/12/2024. Then additional AG shall file an affidavit from the Chief Engineer PWD National Highway on the next state listing as the respondent number 20 has not entered his appearance till date In letter 21/1/2025, the chief engineer Nagaland has mentioned that as and when the works instructed to respondent laboratory would be complete in the root crust would be restored and strengthened. The department will pursue it more for blacktopping of the stretch within the jurisdiction of PWD National Highway. An affidavit to be filed with chief engineer. So affidavit is filed, Lordship.
Now, the Supreme Court have also passed an order to complete this by September 2025. Isn't it? NHA decision?
Contract period schedule time.
Huh? By September,
Malad, the-
September 2025?
Yes, that is the,
Because that is the order, seems to be the 15th April 2024 order. In case there is any delay in construction beyond September 2025.
yes.
Shall move an application before the High for extension. The
That
the
was
application will
65
state that give reasons for a delay. They will pass.
Malad, that was as per the contract
Hmm.
agreement.
So, Mr. Takamas, what are the 3, 4, 5 things we are need to deal with this case now in the order? One will be Chinese 126, where there has to be certain directions issued
Yes.
for the purpose of the acquisition proceedings being
Yes.
initiated
Yes.
at the earliest.
Yes,
And if necessary, to invoke the urgency provisions.
exactly, Lordship.
So that once that land is being taken away by invoking the urgency provisions, then possession be taken and thereafter whatever will follow.
Lordship.
That is one. Then comes Chinese 141 has been duly done.
Yes.
We are not concerned with that. Then comes another thing is 127 plus 230 has been completed. So that has been done.
Yes.
Now the problem is another chain is 124 plus air required removal of overhanging rocks and the works related. This has been done.
Yes. That is under progress. So
Which one? The rockfall barrier?
Only paragraph 19, Lordship, only paragraph 19, filing an audit of reply.
So
attached
there
by-
they have said that this is by, so we only now in this order deal with 126.
Yes.
Then should we need to deal with that order of as regards the short-term maintenance contract for scaling, hill sloping and installation of rockfall barrier in the instant proceeding in the present order? No. Because this is till 31/5 it
Yes.
is there. So we need not now look into this aspect. Because what is happening, Mr. Takama, so what is happening as I could see from the order, it's all jumbling up of various issues being taken. We need to simplify because we are only a monitoring court, nothing more than that. Because if we now act in something, because we certain aspects which we cannot decide,
Yes.
but we can only direct, we can only pave the way
Yes.
so that that can be done. Then
My lord, Bailey Bridge is
Bridge.
under construction, so
Huh?
Bailey Bridge, paragraph 22, 23, it appears
They are constructing.
they are
So
constructing.
Bailey Bridge, there is no problem.
Yes.
We are only having the problem with the chain bridge at chain is 165. Chain is bridge at chain is 165. The problem here is towards here.
The bridge, yes.
There's some problems being created by certain persons. In spite of the construction being carried out in the acquired land. So for that, appropriate orders required to be passed to the Deputy Commissioner as well as the SP.
Yes.
Then 164.
This will be the DC
Kohima.
Kohima and SP Kohima.
Lordship.
Then we are concerned with
Thinking area at 164, Lordship.
There is one.
164.
Where the two colors are.
Thinking area 164. What is the problem here?
The landowners are complaining regarding the building of the culvert because the water.
Oh, this is the culvert business.
Yes.
Okay, culvert. Culvert. So here the question is, if you have now given a design,
Desire.
there are two alternatives being given by you.
Yes.
One is by using a culvert
Yes.
and the other is a bridge.
My lord, culvert is for the temporary purpose, for immediate requirement.
So the culvert is for immediate purpose.
Yes.
And the other is for a bridge.
Yes.
Permanent. So this bridge, this bridge, if it is to be carried out, it will have escalation of the prices.
Yes.
Yes.
And there might be a further new contract may have to be given for that, which is outside the purview of the present contract. So as per the present contract, it is the culvert.
Yes.
Although they have given this option,
Yes,
but
yes.
it is the culvert.
Yes.
So as regards the bridge, you will take a call later on if
Yes,
need
yes.
be.
Yes.
So as regards the culvert, they are not in a position to carry away because of some disturbance being created by the. So the required direction, Mr. Takamasu, would be for the NHA, DCL and district administration
Yes.
to have a talk with these people and sort it out.
In a time bound manner, Lordship. There will be a
Within a
time bound manner.
time-bound manner, they
Okay.
have to sort it out,
Yes,
taking
yes.
into account that there is a, the construction of the work has to be completed.
Lordship.
Yes.
And any further directions
Then,
in
my
that
lord,
regard?
the last,
No. We'll come to the last.
yes.
Here, any further directions do you suggest?
I think that is.
In
Other two
this
are the
regard,
prime.
no, more, in a more finer tune.
Yes, that will be.
Means just asking them to talk out there, they may not bear any fruits at the end of the day. So do you suggest that we should give specific directions how it is to be carried
So
out?
these are the main issues for the moment, Lordship.
Hmm?
These are the main issues for the moment.
No. Dear, should we pass specific directions in this regard, how they have to negotiate and take over the land? It means for the purpose of construction of the culvert, what do you suggest being the amicus? You see, what is the suggestion? What they say, there are two ways. One is the permanent, which will have a bridge, which will be a different contract altogether.
Yes.
The second is the culvert, which falls within the scope of the work.
No.
Now, for the purpose of construction of the culvert, there is a likelihood that some water will be diverted to the lands of other people,
Yes.
which the other people, therefore, those people are objecting to it. So the question now, therefore, is what directions this court is required to pass in that regard to solve that issue.
One the issue is unless and until immediate compensation or some relief is given, assurance is given to the landowners. Before the rainy season, it will not be possible to complete. So that is my concern.
But when they have not brought it before me, us, that these people has to be compensated, would it be proper on the part of this
Well,
court
that-
now
that-
to pass that order?
My lord, unless some time-bound direction is given so that if necessary, let them submit a report before this honorable court.
So
But then
we-
time is the essence,
so
because
therefore-
we have only 1 month. Within 1 month, this has to be done.
So therefore, what is required to be done is, we need to fix this matter after 2 weeks.
Lordship.
And in the meantime, the NHADCL, along with the district administration, will try to sort out the
Lordship.
problem.
Lordship.
And if the problem cannot be sorted out by bringing it on record by filing an affidavit.
Lordship.
I
Lordship.
think that is the
Lordship.
more proper
Lordship.
way.
Lordship.
Okay, so this is how we take off 164, 165, 1. Anything more? Now the blacktopping, they have done
Yeah.
it.
My lord, like topping, there, my lord, Lordship has this. Actually, there was a direction for like topping within 3 months. There was no prayer for extension of time. Then Lordship, they have put some leveling, but then it's
Solving it.
little drizzling, and then the problem because it's only mud. I have seen all of us as Lordship has must have has seen it yesterday. So unless some thing is done there, again the initial portion may be completed, but we will
Now,
face the
why
same
is the
problem.
state doing the blacktopping?
National Highway Chief Engineer.
No. Why is the state doing?
Oh, Lordship, it is under the jurisdiction, I'm sorry. It is not under the jurisdiction of the NHIDC.
How, why? Means the maintenance of the national highway is not under the jurisdiction of national highway?
Only up to package 3.
Only up to package 3. Only up to Chusuma bypass, it is within the jurisdiction of the state government, NHIDC. From there till Liri Bridge. Till there is
Oh,
very
this
thick.
area.
Yes,
So that bridge,
12
is there 160 till 164.
12.64 kilometers is within the jurisdiction of National Highway.
Okay, you are saying this blacktopping is only for this area,
Lordship, only, yes.
where there is also also
Only the sinking area, Lordship,
sinking
about
area.
half a kilometer. Only that sinking area I'm concerned, Lordship. From Chusuma bypass till the petrol pump. The first petrol pump as we come up.
Oh, yes.
Yes, if that portion is blacktop, then
Oh, this is outside the.
Outside the
outside the purview
present
of.
project.
Okay.
That is starting from the Mondir, Mondir down there, and if you come up again.
But
there's a
does this
baseline.
land, the road go to connecting the other bypass? The
No,
Kohima
Lordship,
bypass?
no, Lordship.
Where is the Kohima bypass is being
It is
pushed?
going
They are
to
having
the High Court
another.
side.
It is under construction. Bypass is still under construction.
No, understood, but it touches where? From the main road, the
High Court side.
NHA, because that bypass is done by the state again?
It diverted up to the Joxma bypass patch.
Hmm.
The 4-lane continues. with the road.
Okay.
Bypass.
Lordship, here regarding that, blacktopping, we have completed our job, even though it was beyond the schedule. But this year, last year, there was a delayed monsoon and all. And there were some unusual rain also. So for which we could not go for the complete job. That
Lord.
complete job could not be completed. And as stated in my affidavit, that for
But
blacktopping,
Mr. Imsang, tell me one thing, at the end of the day, are you giving up Kohima?
That is the issue.
yeah.
Are you giving up Kohima? That whatever may be.
And what about
we are not
Manipur,
gonna-
Lordship?
is the state government not worried out there to the effect that this city, this town which is there, or this city which is now coming up very well, requires a permanent solution to the
Lordship.
road connecting the main highway.
Lordship,
So why you are not doing it? What is this mud business
My
of?
lord, and it's only a question of half kilometer, lordship. And
Why
whether
you not doing it?
and to see the state government has no
In,
fund.
in fact, forget about the blacktopping, you should go
Yeah, Lordship,
concrete.
that's only
Because this is
between,
a permanent solution which you require every time.
yes, Lordship. Now for blacktopping, Lordship, we have already addressed to the,
Blacktopping is different. First of all, you needed to make it concrete and
Yes.
then the blacktop.
we have a
Don't you think,
submitted,
Mr.
Lordship.
Thakur? Because this is always required.
My lord, unless that is done, the very purpose of construction of the package 1, 2, 3 will be defeated.
Defeated. This is the main thing. In fact, you should come up properly out there that forget about the blacktopping, which we are trying to do. We are going to properly construct this connection, which starts from the national highway and enters Kohima.
Yes.
This is the most pertinent thing,
Lordship.
unless the government of Nagaland say, we are shifting Kohima somewhere. Then shoot. Otherwise,
Lordship,
you're going to have a problem
In
always.
Kohima, which you celebrate Hornbill every month.
Yes. No, forget
Then
about it.
only we may.
No, I don't come during the rainy season much. I come only during the hornbill when the road seems to be prim and clean. Okay. So
No,
this
my lord,
black.
some direction has to be given.
But I think
Some direction has to be
no,
given.
no. I think Mr. Thagama, what direction is to be given is
yes,
what permanent solution they are always coming up with the thing that we are maintaining. What permanent solution are they having for that road? Because it is also in some areas, if I could see, there is some area which is sinking.
My lord, on the last occasion, after it was brought to the notice of this honorable court had given a direction to the chief engineer to file an affidavit, and the affidavit is filed today. The only explanation given is that they have sought for sanction for blacktopping. It is awaited. Besides that,
No,
nothing is mentioned.
their question doesn't come with blacktopping. There has to be
Yes.
also proper, you have to properly construct this area so that there is no falling. That it doesn't sink. Now, this is the main problem which is being.
Yes, without objective lordship direction was issued the other day, on the last occasion, to the chief engineer to file an affidavit.
Because if I see paragraph number 35 of the last order, had submitted that after grant of sanction for special repair by Mort so-and-so, special repair for reconstruction of protection work, clearance of landslides and restoration of damaged stretch with non-bituminous items of works was sanctioned and an work order was issued in favor of so-and-so on so-and-so with the scheduled period of completion as 3 months. So this work has not been done.
My lord, here, the contractor was completed as respondent number 20 with a direction for the chief engineer to convey.
My lord, here, my lordships, I'm appearing for respondent number 20.
Yes.
The MS Quicker, the work which was allowed to construct repair of roads and this construction of retaining wall. And then as per the work order, I was supposed to complete within 3 months, and then I have completed on
31-3.
12 March, within 3 months.
And that is what Mr. Takamasa is saying, that it's still in a deplorable.
But the work was not bituminous work only. Not, it doesn't include blacktopping. Only clearance of landslides and then repairing of roads, damaged roads, non-bituminous.
Non-bituminous items work was sanctioned.
And then work completion certificate also issued.
Now, what about that retaining wall? Have you done anything to that effect? Was it,
Yes.
has it been done?
Some retaining wall is
It's
done.
been done.
But Lordship, we are traveling every day. So, my lord, we know, we all know the condition. We need not be a technical expert to give a judgment on the, whether, on the condition. So unless and until.
No,
serious report is given-
so the question is, if the work was given
Lordship,
for the purpose of improvement of this particular area,
Lordship,
and the work has been said to be completed, and still there is something more to be done,
yes.
don't you think then that the state is then not asking them to do the work which actually is required to be done?
My lord, since I have not seen the work estimate, how it is done, my lord, I'm not an expert, so I'll not be in a position to satisfy your lordship on that issue. But on the last occasion, I brought to the notice of the this honorable court that in spite of the work order being issued, the work is in deplorable condition. Then last Monday when I visited, I have seen little mud being put. Besides that, and your lordship came last night.
And that was dark.
But your lordship is aware of the writing quality, even if it is dark. So in that kind of a situation, if tomorrow there is little rain, what will happen?
No. That is what my saying, Mr. Tagawada. That if after completion and giving him the completion certificate, something more is still required to be
Yes,
done
yes,
to make that road proper.
yes.
That means they have not given him the actual work to be done.
Because my lord, immediately
Isn't it, Mr.
last year, lordship, it was for removal of the priest and all that. So thereafter, so what was the scope of work? I don't know, the work order, because there was a big landslide last winter.
No, if he has said that he has completed the work, but there's something more to be done.
Yes.
That means it has not been done in actually in what manner it was required to be done.
Something more has to be done, lordship.
Your lordship, the problem is flag topping, we have to submit a estimate to the ministry, road and transport and highway. So we are waiting for that.
No, why
And
did you
immediate-
stop? No, why
yeah,
did you stop?
Yes,
Mr.
your
Imsan?
lordship.
Why did you only say that okay, non-bituminous you completed, and why didn't you add the both? Because if this road is special repair is being given by MOT, why didn't you include that blacktopping there?
Lordship,
Exactly.
your lordship, the problem is in order to meet the direction of the honorable court, also to meet the demand of the public, we have to work out from our own source. So we have engaged a contractor, and for which we have completed his job is already completed. And now the blacktopping, it involves from Chosuma to Liriket is down there. So it one stage we have made the estimate and we have submitted to the ministry. So we are waiting for that.
Okay, let me dictate the order now.
Yes.
Let's see how it takes up. Mr. Takamasa, kindly aid this court while dictating, if anything more.
Lordship.
Yes. Heard Mr. Takamasa, the learned senior counsel, who is also the amicus curiae duly appointed by this court. We have also heard Mr. Imti Imshong, the learned additional advocate general Nagaland, Mr. T.B. Jamir, the learned counsel appearing on behalf of the respondent number 19, Mr. N. Mujoy, the learned counsel who appears on behalf of the respondent number 15, and so-and-so, who appears on behalf of respondent number 20, and you, so appears on behalf of the respondent number 6 and 7. Full stop. Mr. George S. George, the authority engineer in NHIDCL, is also present in person. Full stop. This court, by an order dated 12/3/2025, had given detailed directions, have given detailed directions, have duly taken note of the progress of the work pertaining to the Kohima-Dimapur National Highway and the difficulties which are being faced in the implementation of the said work. In that regard, various directions were issued. First, Pursuant to the said directions, there has been certain affidavits which have been filed before this court, and wherein certain compliance have been already affected. During the course of the hearing, issues arose. During the course of the hearing, Mr. Takamasa, the learned amicus curiae, Mr. N. Mujoy, the learned counsel appearing on behalf of the respondent number 1915, and Mr. T.B. Jamil, the learned counsel appearing on behalf of the respondent number 19, expressed that on account of certain inaction on the part of the respondent government, on the part of the district administration of Kohima, the work has been, the work is in a, the progress of the work has been affected. Taking into account the specific submissions made, this court, we find it relevant to deal with the same specifically as hereinunder. ऊपर लिखी हुई first on the heading. Acquisition of land at Chinese 126 heading.
Yeah, sorry for intervention, Lordship. Kindly include the Deputy Commissioner Chumukitima also, not only the Kohima.
The Commissioner, Kohima and Chumukitima. District Administration, I didn't put it, Deputy Commissioner, District Administration. District Administration and the Police Administration. First is land acquisition at Chinese 126. What heading, huh? The issue pertaining to the land acquisition at Chinese 126 arises in the Pagla Pahar area. In the order dated 12/3/2025, it was recorded that a joint verification was conducted along with the concerned officials of various departments, including the NHIDCL, semicolon, the village council members, semicolon, and the contractor. Upon such verification carried out, it was ascertained that an area of land at measuring 34,285 square feet had already been affected for proper flow of river and similar, and assessment was worked out pertaining to the acquisition of land and the accidental damage. verification report which was made was forwarded to the Commissioner Nagaland, Kohima on 10/2/2025 for further action. First, this court, by the order dated 12/3/2025, had directed Mr. Imti Imsong, the learned additional advocate general Assam, Nagaland, to place instructions with regard to the action taken on the report of the Deputy Commissioner Chumikidema by the Commissioner Nagaland so as to complete the process of land acquisition and expansion of the riverbank before the rainy season. First, next. This court we have heard at length on this issue. First, we have inquired with the learned additional advocate general as to how the state of Nagaland proposes to acquire the land. First, he submitted that the state of Nagaland acquires the land by following the provisions of the Nagaland Land Requisition and Acquisition Act 1965. Requisition and Acquisition Act. Act to bracket 1965. First, taking into account that the survey has already been done, this court have duly perused the said Act of 1965. First, in terms with the said Act, the acquisition is to be carried out in terms with Section 6. By issuance of appropriate notifications. First, we fail to understand that in spite of the report having been submitted on 10/2/2025, and there is a necessity, there is an urgent necessity that the land be acquired at the earliest, so that the progress of the work of the National Highway 29 is not hindered. The learned additional advocate general have, however, not placed anything as to what steps have been taken for acquisition. Have you taken? Mr. Takamasa, the learned amicus curiae, as well as Mr. S. George, the authority engineer, NHIDCL. Mr. Takamasa, learned amicus curiae, Mr. S. George, the learned, the authority engineer, NHIDCL, and Mr. Mojui, you are concerned with this package?
No.
Okay. And yeah, so and so. And Mr. Ezra submits that without this acquisition being done by invoking the urgency provisions, the progress of the work, there cannot be there cannot be a proper progress in respect to the work to be carried out in Chinese 126. We have also taken note of that once the rainy season starts, it will be difficult to carry out the said work. Accordingly, we observe and direct the state of Nagaland, direct the state of Nagaland, and more particularly the Commissioner Nagaland, Kohima, as well as the Deputy Commissioner Chumuki Dima, to take appropriate steps at the earliest so that the acquisition, the land can be acquired at the earliest. In that regard, the said authorities can also invoke the urgency provisions as mandated under the Act of 1965, read with the provisions of the Land Acquisition Act 1894. This is done for 126. Now coming to the next is Bridget Cheney's 165.
165 and 160.
This one nearby.
Yes, Lordship.
The heading: Construction of the bridge at Cheney's 165. The issue involved, the problems so faced in respect to the construction of the bridge at Cheney's 165 as projected by Mr. Mojui, the learned counsel appearing on behalf of the respondent number 15, is that on certain persons who claims that they have not been compensated are obstructing in the construction of the bridge,
Yes.
and more particularly the approach route. A bridge or the approach route?
Only the bridge.
Construction of the
Opposite,
bridge.
yes.
Mr. Anmujoj, the learned counsel, submits that they had given an undertaking before this court that they would be completing the package 3
Lordship.
within by
The bridge or
the entire thing
by May.
31st May.
Yes.
By September.
By September, yes.
Given an undertaking that they would be completing the work, contract work, by September 2025.
Lordship. Of the contract.
He therefore submitted that if the district administration of Kohima, as well as the police administration, district administration as well as the police administration of Kohima, under whose jurisdiction the said area falls, does not take appropriate action, it would be difficult on the part of the respondent number 15 to complete the work. This court inquired with Mr. S. George, the learned, the authority engineer in HIDCL, as to whether the land in question was acquired upon which the bridge is to be, the construction of the bridge is to be carried out. Mr. H. George submitted that the land had been duly acquired. The question of non-payment, non-receiving of compensation is required to be tackled by the district administration, which however have not been done in spite of communications being issued to the district administration. We have given an anxious consideration to the said aspect, and we are of the opinion that if the land had already been acquired, the right of a person, if there is a person aggrieved on account of non-receipt of the compensation, it is required that he approaches the court of the authorities and the law. It is further observed that once a land has been acquired and the possession has been taken, the land vests absolutely upon the government or the beneficiary upon transferring the title by the government. Under such circumstances, no person can claim any right over the land, over that land which have been acquired. If any disturbance as such is being caused by any person, the district administration, as well as the police administration, who are required to control the law and order situation, is required to take appropriate steps. Consequently, this court directs the Deputy Commissioner, Kohima, as well as the Superintendent of Police, Kohima, to take appropriate steps so that the disturbance caused by any landowners, caused by any person, is so that there is no disturbance caused by any person towards the further progress of the construction of the bridge at Cheney's number 165. The said, this court, however, we find it, however, relevant to clarify that if any person is aggrieved, the district administration shall duly take steps for ventilating their grievances by following the due process. Then we come to singing area
164.
164.
Yes.
Let me come back. Huh?
So sorry for the journalist lordship, there's some issue.
In 165.
In 165, before lordship, before it was not brought to my notice, but the authority engineer has.
Yes.
So before reaching the bridge, there is about 600, 700 meter before reaching the bridge. From Kohima side, on a curve, we had to cut the road up to the ROW for widening of the road. That landowner was also objecting, claiming that he didn't get compensation. But we have informed the district administration. The meeting was conducted, joint visit was conducted, ROW was marked. That time administration had told us to go ahead with the construction. Now when the contractor is going again to do the construction of the work, the landowner is again objecting for that.
Before the bridge, there's a big curve lordship. On Kohima side.
Has this land been acquired or not?
Yes, acquired. Within ROW only. Yes. 165, 672, 165, 840.
Which is the area exactly?
Zupsa, before reaching Zupsa from here. It's Zupsa area only. And chainage is 165, 670, 165, 0.670
670.
to 165.840.
Yeah, go to there. Mr. S. George, learned the authority engineer had also pointed out that apart from the disturbance being made in the construction of the bridge at Cheney's 165, there is also certain disturbance caused by some persons. I would not mention them as landowners because they are not. Some persons in the construction of the road and the area in question is from Cheney's 167, 5.670.
165.
165.
165.670.
0.670 to 165.840. Pusto. He submitted that this particular land have already been acquired. And as such, the persons concerned who are making this, who are disturbing on account of having not been adequately compensated, is required to approach, if so agreed, is required to approach the appropriate court and not to create any disturbance. He also stated that this aspect of the matter was brought to the attention of the district administration, Kohima. And the district administration, Kohima, had permitted, had asked, had directed the NHIDCL as well as the contractor to proceed with the work in the said area. But then also the persons concerned, certain persons are disturbing. In our opinion, once the land has been acquired, it vests upon the state to stop. Any disturbance caused thereupon by any person in the land wherein constructions are being carried out would amount to held out requires to be dealt with by the district administration as well as the police administration of Kohima. So that the rule of law is so that the rule of law required to be dealt with by the so and so. Accordingly, this court, we direct the district administration as well as the police administration of Kohima to take appropriate steps so that the construction of the work in the chain is 165.670 to 165.840 can be carried out by the contractor unhindered. Then come to sinking area at chain is 164. Heading 1. We have taken note of the order dated 12/3/2025, whereby the coordinate bench of this court had directed the respondent number 15 to submit the design with regard to the pile foundation work at Cheney's 164 at Jubra to the NHIDCL within a period of 2 weeks, so that the NHIDCL can give due consideration to it and accord approval. First, Mr. S. George, the authority engineer, submitted that there are two the proposals so submitted by the respondent number 15 contains two aspects. One is the construction of a culvert, which is already within the scope of the work. And the other is a construction of a bridge, which is outside the scope of the work. He submitted that for the purpose of construction of a bridge, as it is outside the scope of the work, it would have to be, it would require further approvals and would also come within, and also would be outside the scope of the work. The NHIDCL, in that regard, would take a decision if it is at all necessary at a later stage. However, for the purpose of construction of the culvert, which is within the scope of the work, there are certain problems which are being faced by the NHIDCL as well as this contractor. Inasmuch as certain landowners are not allowing the construction of the culvert on account of, in view of the fact that with the construction of the said culvert, certain water would be diverted to their land and thereby diminish the value of their land. We, having given an anxious consideration to the said aspect, are of the opinion that if any person is affected by any action taken by the state in respect to their property, which is now considered to be a human right, the state is required to redress their grievances by following the due process. First, However, in doing so, there would be a requirement of certain negotiations between the district administration, the NHIDCL authorities, and the persons who would be affected in view of the culvert being constructed. First, we have also taken note of that the area which would be affected, which may be affected on account of the construction of the work, is an area which have not yet been acquired. You're not acquired. First, taking into account the above, we direct the district administration, Kohima,
Yes.
the NHIDCL as well as the NHIDCL to engage in negotiation with those persons who would be affected in view of the who may be affected in view of the construction of the culvert in question. Once we cannot also be unmindful of the fact that the construction of the culvert is required to be done on an urgent basis, taking into account that the period of completion is fixed, but is already a period of completion is by September 2025. And as an end, in the month of June and July, and from the month of June 2025, the monsoons would onset. Considering the above, we direct the district administration as well as the NHIDCL to engage in negotiations and to find out a solution and submit a report before this court on the next date. Because taking into account the urgency in the matter, we fix this, we require the report be submitted by way of an affidavit before this court on or before 15th of April 2025. First step. Next. What the heading di ba? Reconstruction of protection work, clearance of landslide and restoration of damaged stretch of road.
Lordship, the
By
change
the-
is also mentioned in the order.
From the
Lordship, in paragraph 33,
which one?
Lordship, the state highway 172,900 to 185.540.
Of old. Okay. And again, reconstruction, comma, or reconstruction, comma, clearance of landslides and restoration of damaged stretch from chainage 172.900 to 185.540, falling within the Public Works Department, NH, Nagaland, at the heading. Mr. Takuma Sutherland and Micah Curie submitted that the Kohima is the heart of the state of Nagaland. First, the construction of the four laning from Dimapur to Kohima has been made in order to have proper access to the capital city of Kohima. However,
As well as, my lord, kindly take into consideration the state of Manipur. This is the only lifeline.
no, let me. The following from Dimapur to Kohima.
Kohima has been made in order to gain proper access to the capital city of Kohima.
Proper access to Kohima. To Kohima. First. He therefore submits that if this particular stretch of land, a stretch of road, which falls within the jurisdiction of the state highway, is not maintained, the very construction of the four laning from Dimapur to Kohima would be rendered nugatory. He further submits that from Kohima, he further submits that this particular road, he further submits that it is only after entering into Kohima that one can go to other parts of he further submits that this road, the road in question, is the lifeline for all vehicles to cross to which place?
Manipur, lordship, state of.
To the state of Manipur, as well as into the other parts of Nagaland, including the state of Manipur. First, Mr. So-and-so, appearing on behalf of the learned additional advocate general, submitted that after the grant of sanction for special repair by the MORTH, M-O-R-T-H, all caps, MORTH to actually Ministry of Rural Road Transport and Highway, Government of India, special road repair for reconstruction of protection works, clearance of landslides, and restoration of damaged stress with non-bituminous item of works was sanctioned. And in that regard, a work order was issued to the respondent number 20. First, Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 20, submits that within the scope of the work so awarded, the said work had been duly completed within the period of 3 months, and a completion certificate has also been awarded to the respondent number 20. Mr. Takamasa, the learned counsel, learned amicus curiae, submitted that if the work has been completed and a completion certificate have been issued to the respondent number 20, the work which is sought to be done under no circumstances can be said to be a work which can be said to be a work for the purpose of restoration of the road, in as much as the condition is still deplorable. First, we have given an anxious consideration to the above submissions made by the councils. First, there is no quarrel with the proposition that this road that is from Chinese 172.900 km to 185.540 km, is the lifeline to enter the city of Kohima, as well as to travel beyond the state, beyond to travel beyond to other places in the state of Nagaland, as well as to travel to the state of Manipur. First, if the work in question have been said to have been completed, and there is still work required to be done for the purpose of and still the road the condition of the road in question is wanting, we are of the opinion that the state government is required to give a proper it is required to take a serious is required to take appropriate steps so the road in question is maintained in the best possible manner. First, Mr. Imsong, the learned additional advocate general submits that the work order which was issued was not for road topping. What was issued was for reconstruction of the protection work, clearance of landslide, and restoration of damaged stretch with non-bituminous item. First, he submitted that steps have been taken by the state of Nagaland for the purpose of getting the sanction from the MOT for road topping, which and upon such sanction being granted, appropriate steps would be taken. First, why is the MOT responsible for sanction? The MOT will give the sanction. Then it will happen.
But my lord, till then, I think from the state fund, you should ensure that it is properly maintained, because when the sanction will come.
In Assam, I would have ordered, but not in the
No,
state.
but here also, my lord, from GST and others, they have sufficient fund for this, at
Yes.
least for maintenance.
Kamasa, you know GST doesn't function in this
No,
manner.
but not, but
You pay the GST, all the money goes out there.
but whatever, at least they
And
should
then
ensure
the-
that it is maintained.
Then the government of Assam was.
I'm not talking about black topping, lordship, but at least it should be maintained or till the sanction comes. It may take years, but at least for this coming monsoon, my lord, it should be.
Who is paying for MOT? No central government.
My lord, no central government today. But it is the state's baby,
And
lordship.
this submission was made as far back as on 22/1/2025. What is the progress of the sanction? How can you have no instruction in this matter? This is one of the burning issues. Mr. Imsong must be traveling by helicopter. Huh? Your house is in Dimapur, main house.
Yes, his main house in Dimapur.
So how do you travel by helicopter? Huh? And you don't mind. No, March 13, I understand. But the fact remains that this was going on from 22/1/2025.
Prior to that, from November, lordship, first order was issued in the month of November for the road.
কি লিখলে আসতো? We have given a due thought and consideration to the said submissions. Taking into account that the sanction is yet to be obtained, and the road which have been now constructed, the road which have been now repaired, as by the respondent number 20, would be rendered useless if appropriate steps are being not taken of to maintain the said road. We direct the state PWD authorities to maintain the said road so that till proper sanction, till sanction is received from the MOT. The secretary, no?
Respondent number 4, Lordship, Commissioner and Secretary,
The commissioner and secretary,
PWD,
PWD
works and proceed.
government of Nagaland, is given the liberty to take up the matter with on urgent basis with the MOT authorities, so that the sanction is obtained. We further direct MOT will be there.
My lord, respondent number 1.
One.
Yes, 1 and 2.
We further direct
Respondent number 1.
the respondent number 1 to take active steps so that the approval so sought for is granted at the earliest.
Yes.
List this matter.
May I pray, Lordship,
Yes.
the respondent number 4 to file an action taken report for an affidavit with regard to the maintenance.
In this regard, we further direct the respondent number 4 to bring on record the status as regards the maintenance of the road from Chinese number so-and-so to so-and-so on the next day.
Yes, Lordship.
List and the compliance to the above directions.
Yes, Lordship.
List the matter on 16th of April 2025.
Your Lordship, 2 weeks time to file a rejoinder. I will be filing before our next date fix.
What rejoinder?
I am for respondent number 19.
We filed it.
Lordship.
I've not said anything not to
Lordship.
file.
Yes.
We filed.
Much
Because you
obliged.
see, what is required is pinpointing. Means otherwise it will have a disastrous effect. And every 2 weeks, when a judge changes, it will be very difficult.
Pleasure.
For admission, item number 2.
Yes, what is this?
Look, PIL has been filed challenging the 2 amendments that have been brought by the Nagaland government with respect to the Nagaland Lokayukta Act.
Why?
The amendment was there,
Why a PL?
my lord, the issue was there. The Nagaland government was not yet appointed a Lokayukta from the last time. When the last Lokayukta was there, after he reinstated his office, the Lokayukta was not being appointed. Now,
subsequently what happened, the government of Nagaland has brought 2 amendments in the Nagaland Locality Act, which is prima facie repugnancy to the central land. What was that happened is that,
That very well.
my lord,
Why PI?
because it's affecting the people of Nagaland.
Why?
Because if their office of locality is not been appointed,
Any person can file it. Why a PI? You can ask for a qua warrant, read a qua warrant. But why a PI?
because the interest of the larger public is concerned, that's why this PIL has been filed.
No. You cannot file a PI for quashing a legislative enactment. Anybody is aggrieved, he can very well file it. No.
Because when this matter was taken up, it was being heard, and accordingly the order was being passed. If the lordship is having a query that whether PIL is maintainable in this law, my lord will give me a short date, I will satisfy this honorable court. The PIL is maintainable.
Satisfy me now.
My lord,
What is
because
there to satisfy? The question is, how can you maintain a PI? You file a writ. This person concerned, Victor Sifu, can very well file a writ and say that issue a writ of warrant because it's a public office. If a public office is being done, somebody, you file a writ challenging the enactment. How is it possible?
no, even your lordship can take in a view in a different aspect also, if I put it like that. The pair is very limited. That the 2 amendments which has been brought, prima facie, is that it's repugnant to the central legislation. How? In the central legislation, it says that the selection committee, the charge committee, which is to be formed by a panel of certain officials. Now, what they have done in the Nagaland government has done is that they restricted it to the chief secretary and the advocate general. Number 1. Then subsequent amendment which was being brought in was that who will be the Lokayukta? As per the Central Act, a retired judge of a Supreme Court or retired Chief Justice of a High Court or a judge of a High Court. That has to be done. Now, what in this present amendment they have done is that they have widened the scope, saying that any person who is eligible to be appointed as a judge can be made as a Lokayukta. So, prima facie, these 2 are repugnant. And that's the why the writ petition has been filed in the form of a PI. Now, if your lordship says that.
No, what is this? You are referring to the Lokpal Act.
Yes, my lord.
Let's see, the Lokpal Act, but because for a Lokpal Act, there is a particular provision that the state, it doesn't say that the state act has to be in accordance with that. There is a specific.
My lord, your lordship kindly come to section 63 of the Lokpal Act. Section 63.
Yes.
Every state shall establish a body to be known as the Lokayukta for the state, if not so established, constituted or appointed by a law made by the state legislature to deal with the complaints relating to corruption against certain public functionaries within a period of 1 year from the date of commencement of this act. Now, by virtue of this, the Nagaland government brought into a Lokayukta Act. In fact, your lordship will appreciate this fact that one writ petition was filed in the Supreme Court that the Lokayukta office has not been created in the India, various states. It's just registered as ACU Upadhyay versus Union of India. Then even the Nagaland, the other state governments were also made a party. So the state government were apprised the honorable court, the state of Nagaland, that we are going to appoint the Lokayukta. It will be coming into force because Lokayukta Act is there, but we are going to appoint a person. And on that matter, the state government said that we are going to make some amendments in the provisions of the Nagaland Lokayukta. The Supreme Court said that we are not interested whether you are going to do it or not. Then the matter came up that they are going to appoint it. So one Lokayukta was appointed at that point of time. Subsequently, some developments happened. The earlier Lokayukta demitted the office. Now, what happened is that if your lordship will kindly see section 3 of the establishment of Lokpal.
No. First and foremost, what is the power being exercised for making this act?
Well, it has been exercised in 2 powers. One was that the Indian government is a member of United Nations Council.
No. Let's not go there. Power, when you make an act, the power has to be from the list.
Concurrent, madam.
So the state has the power?
State also has the power.
Now, is the state act
Yes.
in conflict with the central act?
Yes, madam.
Where is it?
Yes, your lordship. I will show you. Kindly come to section 3. First is section 4. 4, 3 of the central act.
Yes.
Appointment of chairperson and members of recommendation of selection committee. Kindly come to subsection 3.
Hmm.
The selection committee shall for the purpose of selecting the chairperson and members of the Lokpal and for preparing a panel of persons to be considered for appointment as such, constitute a search committee consisting of at least 7 persons of standing and having special knowledge and expertise in the matters relating to anti-corruption policy, public administration, vigilance, policy making, finance, including insurance and banking, law and management, or in
No, this
any.
is for Lokpal.
My lord,
Then why should the Lokpal be the same as Lokayukta? Where is the qualification, eligibility criteria for?
Your
How
lordship,
dare you
I
mistake it?
your lordship, first is search committee. If your lordship will see, the search committee has to be created, has to be constituted to select Lokpal and Lokayukta in the Lokpal in the center. The Lokpal in the center has to be a retired Chief Justice of a Supreme Court or a judge of a Supreme Court. Similarly, as per section 63, every states are bound to make the law. So every state in the Lokayukta, as far as state is concerned, they has to make a Lokayukta, office of Lokayukta through a retired judge of a Supreme Court or a Chief Justice.
Why do you say so?
Because the act says so, my lord.
Because this act only is for Lokpal. This is not for Lokayukta.
No, your lordship, as per section 63, the state has to make a law.
Yes, but where does it say the state law has to be in terms with this? Why are you saying about a High Court judge to be a
Your
Lokpal?
lordship, the act is there.
No, does this act say that a High Court judge can be?
My lord, the state act says there.
No, forget about the state act. Does the High Court, this act say so?
Your lordship, kindly see my section 3, section 3.
Yes.
Section 3.
Yes, what does it say?
Establishment of Lokpal,
Hmm.
on and from the commencement of this act, there shall be established for the purpose of this act a body to be called the Lokpal.
Hmm.
The Lokpal shall consist of a chairperson who is or has been a Chief Justice of India or is been a judge of the Supreme Court or an eminent person who fulfills the eligibility specified in clause B of subsection 3.
Hmm.
And such number of members not exceeding 8 out of 50% shall be judicial members.
Hmm.
Provided that not less than 50% of the members of the Lokpal shall be among the backward belonging to scheduled caste and scheduled tribes, OBC, minorities and only. 3. A person shall be eligible to be appointed as a judicial member if he has been a judge of the Supreme Court or has been a Chief Justice of a High Court. B. As a member other than judicial member if he is person of impeachable integrity and outstanding ability having special knowledge and expertise of not less than 25 years in the matter relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management.
But where does it say that it is for Lokayukta?
My lord, the lordship will appreciate this fact. The Lokpal Act was being enacted by the center. Accordingly, the Act says that under section 63, every state has to make a Lokayukta. Now, state will be making under what law? They will be making under the concurrent list. Concurrent list, because union also made under concurrent list. Now, state has made a law. Now, your lordship, if two acts are conflicting,
Where is the conflict?
your lordship will kindly see.
Is the state making up a law for Lokpal?
Pardon me, lord?
Is the state making a law for the Lokpal?
State is not making the law for the law.
Then how is it a conflicting?
My lord, in the state,
How do you bring the High Court judge out there? I understand. There is out here only the Chief
We have to-
Justice.
my lord-
What is on what basis are you say that the High Court judge should be there? Then every Lokayukta should also be a Supreme Court judge. As per this, if
now,
we
as
go
per
by
the
that,
act, Supreme Court, Chief Justice or Supreme Judge of a Supreme Court. That is a
so he
Lokayukta.
has to be there.
Yes.
So if we go by this, then every Lokayukta also has to be there.
Lokayukta has, in fact, it is a Judge of a Supreme Court or a Chief Justice, former Chief Justice.
Lokayukta.
Lokayukta.
What is the basis on which you are saying? Because of this act? No, that cannot be the basis.
Your lordship will kindly see the Nagaland Lokayukta Act.
Yes.
Appointment of Lokayukta and Upalokayukta, your lordship will find, I have annexed it in page 32.
Yes.
Your lordship will see the first challenge which was been made was that with respect to the composition of the selection committee that was been brought in the Amendment Act of 2019. which I say it is repugnant to the main act of the Lokpal. Because here the selection committee.
No. Here, as per this, who can be a Lokayukta?
Your lordship will kindly come to subsection 4 of section 3.
Member of a parliament shall
Of
not
course,
be.
no, my
Shall
lord.
not. This is a disqualification.
No. I'm looking for the PDF file, your lordship.
No, you don't read from a PDF. You give us the file which we are holding.
The lordship, a person.
That is challenging.
Your lordship will kindly come section 3, 4.
Yes. Shall
Section
not be
three itself
qualified
points out-
for appointment unless he has been a judge of the Supreme Court or the Chief Justice of a High Court or a judge of a High Court, or a person qualified to be appointed as a judge of the High Court, or a person with vast knowledge and so on. How many is the Lokayukta?
My lord, there has to be one Lokayukta.
And member?
Upalokayukta will be there. And there has to be
No.
members.
Member. What is the constitution of the Lokayukta? Because here there is a mention of some judicial member.
Judicial member.
So where is the appointment of a judicial member?
Your lordship, in section 3, which I am referring, there talks about Lokayukta and Upalokayukta, which talks about members also.
Where is the member? Member? No member.
No member.
Means Lokayukta office will be alone.
Lokayukta and Upalokayukta.
There will be only one. Either a Lokayukta or a Upalokayukta.
No, Lokayukta.
They cannot be both. Therefore, they mention everywhere Lokayukta or Upalokayukta.
There will be Lokayukta assisted by 2 Upalokayukta.
Where?
Your lordship will kindly see section 3. Let us read the section 3. For the purpose of conducting investigation and inquiries in accordance with the provisions of the Act, the governor shall by warrant under his hand and seal appoint a person to be known as Lokayukta, that is one person, and now exceeding 4 persons to be known as Upalokayukta. Subsection 2. The Lokayukta shall be appointed by the governor in accordance with the recommendation tendered by the selection committee consisting of the Chief Minister of Nagaland, the Chief Justice of the Gauhati High Court, Speaker of the Legislative Assembly, and the Leader of Opposition in the Legislative Assembly of the state. In case where there is no recognized Leader of Opposition, the consultation shall be with the Leader of largest opposition party in the Assembly. In case the Speaker of the Legislative Assembly is not available for consultation, the consultation shall be with the Deputy Speaker of
So
the
3-2 is good.
What another?
3-2 is good.
3-2 is good.
3-2 is as per even the
Central.
Constitution bench. No, not only that, the Constitution bench also. Yes, then 3-3.
The selection committee shall, for the purpose of selecting the Lokayukta and for preparing a panel of persons to be considered for appointment as such, shall be guided by a search committee constituting the Chief Secretary to the Chief Secretary or the Additional Chief Secretary and the Advocate General of Nagaland, which has been brought by 2019 amendment, which is put to challenge.
Selecting the Lokayukta and for preparing.
No appointment of Lokayukta or Upalokayukta at the state shall be invalid merely by reasons of any absence or any member entitled to be consulted in terms of para 2(1) supra at the time of the meeting convened for consultation. The Upalokayukta shall be appointed by the state government after consultation with the Lokayukta. A person, subsection 4, which has been brought after amendment of 2022, a person shall not be qualified for appointment as Lokayukta unless he has been a judge of the Supreme Court or the Chief Justice of a High Court or a judge of a High Court, or a person qualified to be appointed as a judge of the High Court, or a person with vast knowledge of law and experience in judicial matters or courts of a person or impeachable integrity, outstanding ability, having special knowledge and expertise of not less than 20 years in the matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking law and management. Now, your lordship will kindly see the selection committee, which is there in the parent act.
Mr. Advocate General,
My lord.
why are you having the I understand for the Upalukayukta, because if you see the central act, although I am of the opinion, means subject to what my brother says, the Lokayukta as have been given in the Lokpal Act would not obviously affect you.
Please.
But that is a law made by the center, and you have a power to make the state. That is one aspect. So there is no violation of 254.
Please.
But the fact remains, if you are having a Lokayukta and you are having an administrative officer, the very edifice, you may very well have the Lokayuktas to that effect. But why you are having the Lokayukta in a person who has been on the administrative side? Because the basic idea of the Lokayukta and the Upalokayukta, if you can get the act fixed out here, is that these persons should be getting the benefit. You see the introduction, the need to have a legislation for Lokpal has been felt for quite some time in the interim so and so. The reason which have been given is setting up of institution, reason, policy of a so and so establishment of locality, inquire into allegations of corruption against certain public functionaries and for matters connecting thereto. The Act creates a process for receiving and investigating corruption complaints against public officials, including Prime Minister. This is for Lokpal.
Lokpal.
This is for Lokpal. Now, in your case, also, you are doing against the public officials. This is the basic idea for the Lokayukta Act. Now, how do you put the Upalokayukta? Because the Upalokayukta has also to be a judge by High Court.
Not necessary.
No, not necessarily.
Even the Upalokpal, they are not judges.
No,
They
no,
are
no, no.
ex-CBDT chairmen.
No, Mr. Advocate General, kindly see the definition of 3.5.
Right.
3.5 says three four says about the who can be a Lokayukta.
That includes all the judges mentioned
Huh?
therein. That includes the various judicial points also kept here.
You can have a judge of a Supreme Court or a Chief Justice of a High Court
My
or
lord.
a judge of a High Court
Correct.
or
And-
a person qualified to be appointed as a judge of a High Court.
Correct.
Which means a person who has the 15 years or 10 years of service as a lawyer
Please.
can become. You
That's the
can
point.
very well make our addition Advocate General also. That is them.
Then, my lord, then
Or a person with vast knowledge of law and experience in the judicial matters, or courts of or a person of impeccable. Now, what happens out here, the moment an or is being given out here, or a person of impeccable integrity, outstanding ability, having special knowledge and expertise of not in the matter of So here, any other person, even a police officer can be made out here. A lookalike. Isn't it?
in Human Rights Commission, this issue arose even when the police officers were being made as members. But for certain reasons, they were required, so they were not touched. The basic purpose of this, my lord, though I will be filing a detailed affidavit on this, the basic purpose here was we were in a big quagmire as far as Nagaland is concerned. In the last 60 years, I think only a handful of judges from the district judiciary have been elevated. And if you see the number of judges for the last 6 decades, that is also a handful, my lord. So, in spite of that, with great fanfare, we appointed accordingly the best person available there, Chief Justice. in one of the northeastern states. So we thought that we had no objection to going into any other thing. Our experience was far from good, my lord. So we were constrained to file a petition under Article 32 for his removal. And the Supreme Court was about to remove him when at that time he said that I will resign, he had to resign. So in this quagmire, what actually happened there was, in the light of the fact that we don't have judges, which is a genuine problem, whereas in other states, you have enough judges to make a selection. Here, at the most, if you go for a retired judge, you will have only one retired judge. So there won't be any effective
No,
selection.
you may not have a Supreme Court judge. You may not
No,
have
not Supreme Court.
justice
I'm saying
of the High Court, or
a
even
high-
a judge of a High Court. You may not have.
That's right.
You still have persons having having the qualifications to be a High Court judge. If I'm
That's
not
right. Yeah, that's right. So all these people will come in that. Those who are qualified to be appointed as a High Court judge.
that has to be gone in terms with the Constitution.
Correct. And the Constitution says 45 years.
Who can be a High
They-
Court judge?
They are not appointed before 45 years. So those who have put in that, we just made it quite elaborate. Not that somebody immediately will be appointed or not. Then, my lord,
Please see what is going to happen. If we say you make a police officer tomorrow a DGP, let's take the case of a DGP. You make him a Lokayukta. You can very well make him in view of this because a person impeccable character, integrity, outstanding ability, and so having not less than 20 years in the matter of anti-corruption policy.
Correct.
DGP may obviously come in. Okay. Now for Upalukayukta, you are going to make a High Court judge also. See from your thing. A person shall not be qualified for appointing as a Lokayukta, Upalukaya, unless he or she has been a judge of a High Court. Then how do you take care of this situation?
my lord, in Upalokayukta, we are appointing even people who have been district judges. There's a extent,
Understood. Everything is
Yeah.
understood, but you can still have a High Court judge.
if it's available. We are keeping it very wide open. The problem we are facing is we don't have. It's a peculiar circumstances which I will be able to establish in a detailed affidavit. Our problems are not anything done to deviate or get ourselves exonerated from anything. Our bona fides were shown right from the inception when we appointed the Honorable Chief Justice. So I'm not saying that every judge who will be appointed will be like that. I'm not saying so. So we were compelled, our back was to the wall because we don't have judges, unfortunately, my lord. Only now more judges are being appointed. So they are being eligible to be appointed. We had a peculiar problem in these things. So this will be considered.
No, but Mr. Education, the thing is, even a district judge can, who is retired, having that experience, can also be a Lokayukta. See, what is required for becoming a High Court judge is this
10 years, my sir.
appointment day, that a judge may be in writing either he has at least 10 years of
That's it.
held a judicial office in the territory of India.
That's it.
A district judge who has held 10 years has at least not less than 10 years been an advocate of the High Court or 2 or more courts in succession. So you have those people out there. But what is happening? You are asking the head of the institution to be a person to head these public officials as regards the brigade against corruption of the public officials. That is why the basis on which the Lokpal Act is being made is that you don't bring in anybody. Yes, for other members, you can very well bring many other people. But for the Lokayukta, the Lokpal, they have never thought that the Lokpal will be done by anybody else.
That's right.
There might be a problem. Yes, for a purpose out there, tomorrow you may have any official in your chief secretary. I'm not saying about this thing. Well, let's take an example. The chief secretary, a person who you have appointed him and he becomes a big problem. But that doesn't mean that you are going to change the eligibility of the chief secretary.
I will make a detailed affidavit explaining the legal, factual, and the complications in this case.
Because their basic idea is that.
That's,
Okay.
my lord,
You
I
also-
have in mind, with your lordship's
Because
permission.
the idea, whatever idea is that, you see, a person has been given from a judicial background.
That's right.
If you see 3-4, till or it is okay. A person, everything is okay till judicial matters or courts. A person shall be not qualified unless so and so a judge as a judge of a high court or a person with vast knowledge of law and experience in judicial matters or courts. Till there it is okay. But here the remaining part which is being brought falls within the, actually you should have it for the lokayukta, upalokayukta. But making them, you are not a, this is absolutely falling within the judicial office. You may not have a judge, but a person who is capable of becoming a judge. As per this article 217.
That's right.
Your lordship is Article 270.
My lord is right there. And therefore,
217.
270.
Yeah. So as per 217, you can very well think about it. There are many other people. And that is why the first basis of your definition, who cannot be a law, who can be only a lokpal, a lokayukta, is on the basis of he has some judicial knowledge. I don't say that, yes, there are problems. And we have seen there are a lot of problems being faced in many of the states. In fact, in Assam also, we are facing a dearth of retired high court judges who are willing to take up many tribunals. We have a land grabbing act. Now there is no tribunal being made out there because of the fact that it has to be manned by a high court judge, and there is no high court judge, retired high court judge who can take it up. Difficulty is facing out there in the consumer forum out there. These are problems being faced, but the fact remains, if you are giving this judicial, a determination of a judicial determination in the hands of a person who is on the administrative side, may have an impact. Although you have a good case for the purpose of maintainability. As regards 246, there is no violation to this act. But it goes against your intent and purpose of your act, which is the Brigade Against Corruption of Public Officials. That is the only thing.
we are concentrating primarily.
You are the Advocate General for it. Obviously, you can very well suggest your government in respect to 3-4 to that effect. Because it is not required that he has to be a judge of a court. Anybody else, even a district judge can also become it, who has 10 years, or even, as I said, our additional Advocate General.
Only thing, person has to be impartial.
Person has that's it.
Integrity should be perfect.
Yes. And how do you remove the lokayukta?
Well, that is done through the assembly. Honorable Chief Justice.
Because I don't find any fault in this thing as regards 3-2. There's no fault out there. 2-2 or 3-2. 3-2 is okay because that is how everything works. This is being done as per the new act, what you call the recent election commission's thing, with the Supreme Court judgment out there, by which, as regards by constitution bench judgment, so there is nothing out there. Here you may give an idea to your government. Take a call on 3-4. Remaining is everything is good. All other.
We will put it in our affidavit, my lord. Certain things which will match with what your lordship has in mind. It's not different from what we have in mind either. We have tried everything. Basic thing is he should be a judicial purpose man with sufficient experience in dealing with judicial matters.
Okay.
I'll make a proper affidavit on that.
Yes. When are you filing your affidavit? It's been pretty long. And the question of maintainability has to be kept open, huh?
Please, my lord. That is.
So where is what interim order is here?
The interim order was to stay the operation of the two amendments.
Absolutely no. There cannot be an interim order
Yes,
in a
you
PIL.
can stay the act.
Never heard of a PIL interim order.
When I prayed for and the court, this division bench, not the order.
It cannot be an interim order. I'm not going to hear. After hearing this court is of the opinion that no, full stop. No interim order business.
Staying an act.
And an act cannot be by way of a legislative act, can it be? In the stop? Will be, let me come back at two. I'll
Please,
pass
ma'am.
the detail order in respect. The interim order cannot be there against the legislative act. It's unheard of. We'll have a
Even
repercussions.
Proceed with the permission.
With your permission, Lordship, it may mention item 9, Lordship, if it can be upgraded, Lordship. After this matter.
Maybe, Mr. Lordship, I pick to mission at number 10. Here, we have already completed, but I need some more clarification. So this matter will be listed on 9 of this month. Next
We'll
week.
see when the matter says. You want an upgrade, I can upgrade. You want an upgrade, I can upgrade it, but not to delist it today. We'll have it later on. Yes.
Mention. You wanted to mention?
No, I'm.
No mention.
My lord, has put one question to me just before the recess. That
First, Mr. Burawai, tell me,
my lord,
have you ever heard a legislative enactment being stayed?
my lord, I will come to that point. I will
Now
come
come to that point only
I will
first.
come to that point. Before that, one question which your lordship put to me. Under what capacity the enactment was being done under the Lokpal and Lokayukt Act? Madam, may I kindly see the statement and object of the act?
Yes.
The Lokpal and Lokayukt Bill seeks to provide intermediate for setting up the institution of Lokpal for the union and Lokayukta for the states through a single legislation, and these bodies will have a constitution status for which a constitution amendment bill is being introduced. Now, this says that it has a one consolidated statute. Now, what was the object behind it? The object can be traced to India is committed to pursue a policy of zero tolerance against corruption. India ratified the United Nations Convention Against Corruption by deposit of instrument of ratification on 9th May 11. This convention imposes a number of obligations, some mandatory, some recommendatory, and some optional on the member state. The conventions inter alia advises that such parties ensure measures in the domestic law for criminalization of offences relating to bribery and put in place an effective mechanism for its enforcement. The obligation of the convention with reference to India have come into force with effect from 8 June 11. As a policy of zero tolerance against corruption, the bill seeks to establish in the country a more effective mechanism to MPs, chief ministers, MLAs, public servants, and to inquire into them and take follow-up actions. The bodies, namely Lokpal and Lokayukta, which are being set up for the purpose, will be constitutional bodies. This setting up of these bodies will further strengthen the existing legal and institutional mechanism, thereby facilitating a more effective implementation of some of the obligations under the aforesaid convention. Now, your lordship may kindly look into the 7th schedule of the constitution.
Yes. Yes.
Article 246, union list, this is the list under which the center has been empowered to play. Now, your lordship will kindly see as serial number 12, United Nations Organization
Of
of the central list, union list. The 7th schedule, madam.
list one.
List 1. Article 246, 7th schedule, list 1.
Yes.
Article 7, Schedule 1, list serial number 12, United Nations Organizations. So, if India being a member of
Yes.
United Nations Organizations, and India as a in the Committee of Nations, India has also certain obligations under the regulations of the United Nations Organization. So, according to that regulations, to check the menace of corruption in the high offices, India ratified that treaty. And on the basis of that ratification, the Lokpal and Lokayukta Act was being enacted as a consolidated. So, the power is under the union list. And section 63, which I was referring at the first half, is that the states are obliged. The states are obliged to enact the law of Lokayukta. Now, my lord, your lordship will appreciate one thing. The petitioners before your lordship, what is the vested interest in this matter? When this matter was there, Lokpal and Lokayukta Act was being brought in. It was not being given effect. It was a paperless tiger, paper tiger, I would say. So one writ petition was filed by Ashwini Kumar Upadhyay. A number of orders were passed. Acting force of that, this Lokayukta Act was brought in place in Nagaland. Now, your lordship, in the first half, your lordship was prima facie of the view. Perhaps I was not better able to present to your lordship. The 254 won't come into play. My lord, I am afraid, with all my humility in my command, I must say that it is applicable because the object of the act has to be seen. Object of the act has to be seen. When the object of the act was there, that we will have a single legislation. Through a single legislation. So what the center did was that in its wisdom to parliament, that as per section 63, let the state make the law of Lokayukta. Now, Lokpal and Lokayukta has to be a constitutional body. Lokpal, can you imagine, like for example, a Lokpal?
Lokpal and Lokayukta constitutional post.
No, we have a constitutional status as per the object of the act. Now, why? Because those offices which will be prosecuted, they will be holding the high offices of Prime Minister, Leader of Opposition, Chief Ministers and all.
Where is it mentioned that it will have a constitutional?
No, my lord, your lordship, can you see the statement of object?
No. You cannot do so because a constitutional post will be a post which is given in the constitution.
Exactly, my lord.
Then
No, my lord, what I was trying to impress is that the object was that it will be like a constitutional body with one particular.
it cannot be a constitutional body also because it does not mention.
It is not coming under the constitution. But your lordship will agree to this. My lords will agree.
Just for example, the Human Rights Commission cannot be a constitutional
No, my lord.
body. It is the creation of an act.
Act. So now the act has been brought into place as per the Lokpal and Lokayukta Act 2013, coming into force from 2014. Now, if a lordship will see Lokpal, the office of Lokpal is to be occupied by a former Chief Justice or a judge of a Supreme Court. It paused there. Now, how do you appoint them? It will be appointed by a committee of persons under the Act, where the Prime Minister, Leader of Opposition, a Chief Justice designate, or the Chief Justice, they will decide. And how they will decide? They will be deciding on the basis of a selection committee who is being constituted under the looking into the diverse nature of the people of our country. From their representatives will come and select and put the name before the panel. Now, as your lordship was correct, their constitutional bench judgment has come regarding the EC Act. Who will be appointed? How it is to be appointed? The Honorable Supreme Court took the view that the EC Act, till a permanent secretariat is being constituted, it will be done in the manner how the Lokpal has been done in the judgment. Now, my argument is that as prima facie, I can demonstrate that it is a single legislation and that is substantiated by the statement and object and by section 63 of the Act. Now, you make a Lokayukta that the state makes. The state says that as judge of a Supreme Court or a Chief Justice of a High Court or a judge of a High Court will be eligible. It's fine then. It's fine. But the selection committee will be the Chief Minister, Leader of Opposition, Speaker, fine, agree. But the charge committee, who will be there? The charge committee in the present act says it has to be, as per the law act, there will be 7 persons, committee of persons, who are representing the various fields. Now, in the present act, what has done?
No. First, answer me one question. Is there any eligibility criteria given for the Lokayukta in this act?
My lord, eligibility criteria is there, my lord.
Of the Lokayukta?
Look, no, in the present act, in the central act, no.
So then on what basis are you saying that the Lokayukta being made, these are the qualifications are wrong or goes contrary to
I would say that I may be wrong, but to the limited knowledge, the enactment of Lokayukta Act, PSI of Nagaland or any state, is a delegated legislation by virtue of section 63. Section 63, because section 63 of the Central Act directs
if it is a delegated legislation, So in that regard, when the delegation does not define what is the requirement of the eligibility for the purpose of Lokayukta, then what is the logical conclusion?
Your lordship has to give a purposive interpretation to the act. Why? If in the case of Lokpal, it will be the Chief Justice of a Supreme Court or a judge of a Supreme Court. Pause there. Then, why the Lokpal will be restricted to Prime Ministers and MPs and other dignitaries in the Union? But when it comes to state, it is saying that it has to be the Chief Justice of a High Court or a judge of a Supreme Court or a judge of a High Court. Because they will be looking against the corruptions, against the allegation of corruption against the high offices occupied in the state. That is the Chief Minister, leader of opposition in the House. So, can it be fathomed that the office of the Lokayukta can be occupied by any officer? Like in the present state of Nagaland, a chief secretary occupied the office of the Lokayukta.
So what is wrong?
My lord, the object, if it was there, if a lordship will take that, in the state it is fine, no need of. But in the center, it has to be the office of the judges of the Supreme Court. I think that cannot be, because my belief.
No, Mr. Burway, we have to understand one thing. This is a legislative enactment.
My lord,
A legislative enactment can be challenged on 4 grounds.
my lord.
First, it will be the competence of the legislature.
Yes.
There's no doubt that the legislature have the competence. Legislature has the competence. Otherwise, you would not be challenging only the amendment. You'll be challenging the act.
Yes, my lord.
So legislature has the competence. Secondly, if it goes against Article 13,
My lord.
second. Third, if it is in conflict with the central law.
My lord.
Fourth, if it is not done as per the procedure established.
My lord.
These are the 4 grounds.
4 grounds.
So your ground first is not there. First is not there.
My lord.
Second is not there.
My lord.
13 not there.
No.
You are on the question of it goes against the central law.
Yes, my lord.
Okay. Now the central law does not prescribe anything in respect to the qualification of the Lokayukta. How does it say go against?
My lord, the one, if we read, let the AG, the learned AG, my senior counsel, can the state say under which schedule this particular enactment has been brought into force? Lokayukta Act. Under what schedule? Can be taken? Because they have taken time for the last 2 days. Under what enactment under what legislative competence they have got the law? To my understanding, the Central Act says that you have to make the law. Now, Central Act, if it is to make the law, you cannot frustrate the object of the Central Act. How? Because the statement of the Act, Central Act, says that setting up of the institution for Lokpal for the Union and Lokayuktas for the state through a single legislation. So it has to be inferred that the office of the Lokayukta, who will be looking after the allegations of corruption, it has to be a person of a former office which has got higher respect, value in the committee of the society. That is why in Lokpal it is the Chief Justice of a Supreme Court or a judge of a Supreme Court. And in the state it has to be a High Court judge or a Chief Justice of a High Court judge or a former Supreme Court judge. Now,
or any other person who has can be a judge of a high court.
if your lordship will take in that aspect, I will because I am not saying this is a personal litigation. It's a the lordship will say that any person under Article 217 who have a standing of 10 years can be eligible for a judge. It's fine, it's there. But does the appointment of a judge is being done in a very everyone is eligible in that case. But there are some criteria behind. The integrity, the Intelligence Bureau's report, the professional competency, the subject approach, that has to be there. But in the Constitution, it is a general saying that anybody who possesses the minimum 10 years can be appointed as a judge.
So why not here also a person who possesses the 10 years of qualification in terms of 217 can be eligible? Whether they are appointed having the integrity or not, that is absolutely within the wisdom of the person who is appointing. Now, if there is an abuse of the process, abuse of the powers by the authorities in appointing a person who does not have the impeccable character or that is a question of judicial review for which there will be a challenge as regards the abuse of the powers.
My lord,
You see, there's a difference between an abuse of the powers for which a judicial review is being done, and there is a question of an abuse. There's a judicial review in respect of an act.
my lord, here the question is that your lordship is correct in as far as the decision making, because if an act has been taken, like for example, an appointment has been done, I have my limited scope under writ of quo challenging the decision making process. That is absolutely agreed.
No, writ of quo warranto will lie against the person concerned
Yes,
if he is not qualified to
Not
hold the
qualified.
public office.
not qualified. But here the issue is that I am saying, my argument is that Section 63 of the Central Acts says, how do we otherwise interpret Section 63? If your lordship says that Lokayukta has not been defined in the Central Act, then how do we interpret Section 63? That is a question will come. Because Central Act says that 63, by Section 63, the state must enact a body called Lokayukta. A body called Lokayukta. Now, your lordship can give me 2 minutes.
Whatever may be. The state legislature gets the power to enact under what provision?
No, that is a question the state has to answer, because I am saying, prima facie I am saying,
I am asking you prima facie. What is the power of the state legislature to enact?
my lord, it will be under the second schedule, second list of the union schedule 7.
So list 2 and list 3.
List 3.
So that is the power
Power.
the state legislature gets.
Exactly.
So can there be, so the power is given by the constitution.
Yes.
Now, if the power is being given by the constitution, can the, by a act made by the parliament, this is an ordinary legislation.
My lord.
This is not a constitutional.
No, it's a legislation.
It's an ordinary legislation. By an ordinary legislation by the parliament, can there be a conferment upon the jurisdiction of the state legislature to enact?
Your lordship, that is the question. That is the question is that because the central government has enacted the legislation by exercising the power under this union list, rule 10, the subject 10, that is the United Nations document, because India became part of that resolution. Now, since the trust was bringing up this legislation was because of the UN, United Nations. So how does the state do it? Because state has to do it. So that's why Section 63 was been put in. And state was asked that you make the law. That is a delegated legislation, my lord, I would say. So if it is delegated legislation, can it violate the Parent Act? That is the main question, my lord. I am not. It is who is to be appointed, who is not to be appointed. That's a subsequent question. Now your lordship will appreciate the other aspect.
Yes.
Now my lord will appreciate the other facts. In the case of Lokpal, the leader of opposition, Prime Minister, the Chief Justice, and the nominee of the Chief Justice will comprise the panel who will appoint on the basis of a search committee, my lord. Your lordship will kindly come to the Lokpal Act. Subsection, Section 4, subsection 3. My lord, is it? The selection committee shall, for the purpose of selecting the chairperson and members of the Lokpal and for retaining a panel of persons to be considered for appointment as such, constitute a search committee consisting of at least 7 persons of standing and having special knowledge and expert.
But this is for Lokpal.
Yes, my lord.
How do you make it for Lokayukta?
No, your lordship. Kindly see. The search committee rules. Your lordship will kindly bear with me for a moment.
Earlier, prior to this amendment, how many people were there in the Lokpal for the Lokayukta search committee?
Your lordship, as far as the earlier act was concerned, These particular selection committees are for the purpose of selecting the locator and preparing a panel of persons to be considered for appointment as such, shall be guided by a search committee consisting of the chief secretary or the assistant chief secretary, advocate general of Nagaland. This was brought in the year 2019 by amendment. Now prior to that, because if I recollect correctly, in Ashwini Upadhyay's case, the government of Nagaland apprised the Honorable Supreme Court that we want to make some amendments in the act. The Honorable Supreme Court said that we are not this amendment, which the search committee was, it was confined to the chief secretary, that is the chief administrator of the government of Nagaland, and the chief advisor, legal advisor, the advocate general. Now, your lordship, just I am putting a question to myself. What is the position of an advocate general? It's a constitutional post. He is the advisor to the government of Nagaland, and he will be entrusted with certain works which the governor might give him. Same with the attorney general. Now, whether in any of the legislation, being in the appointment of the ECI,
This is not an ECI.
no,
This will be a search of the search list.
no, in the search committee also, can the advocate general take part?
He's not. Why not? Why not?
Because the central act in the search committee, your lordship will, that's why I was taking your lordship to the search committee rules. What does the legislation has been done? Section Rule 3. The search committee rules 2014, Rule 3.
So,
The selection committee shall constitute the charge committee consisting of at least 7 persons or of standing and having special knowledge and expertise in the field and from the categories of persons specified in subsection 3 of section 4 of the Act. The selection committee shall nominate one of the members as the chairperson of the charge committee. The secretary to the government of India in Department of Personnel and Training shall function as the convener of the search committee. Now,
yes.
now,
Yes. Tell me.
submission of panel or panels of names to selection committee. The search committee shall submit the panel or panels of name as the case may be for recommendation for consideration of the selection committee. With such period as may be, the search committee shall, as far as possible, in the case of chairperson of a Lokpal, a panel of at least 5%. In the case of members of Lokpal, a panel comprising names of at least 3 times for the consideration of selection committee. While having the panel of names to be recommended, the search committee shall have due regard to the representation of backward persons of the SC, ST, OBC minorities. Now, what my argument is there? Your lordship will appreciate that a law is presumed to be valid. That is the canons of interpretation. So if we apply the canons of interpretation in the central land, because it was being raised in the various matters before the Supreme Court said that it is a perfect legislation because of the conversion of the people. Now, on the basis of this legislation, a body is being created in the state, that is Lokayukta, because I don't see other power under the union or state list or concurrent list. Just it can be made power. So if that is the position, then it must be the act of a state making a Lokayukta has to be in conformity with the overall guidings 4 corners of the central. Because your lordship, if your lordship negate this argument, for example, in the history of the Lokpal, in the institution of Lokpal, whether any cabinet secretary has been appointed as a Lokpal, it's a very dangerous proposition, madam.
Because it cannot be.
It cannot be.
No, it cannot be because it is not.
Because of this agenda.
But he can be a member. But this act makes it clear that who can be a Lokpal.
My lord.
But in Lokayukta, they have made it clear who can be a Lokayukta.
Your lordship, before also they were saying the judge, chief judge, judge of a Supreme Court, judge of a High Court, or chief justice. So I am saying that it was fine at that point of time, pre-2022. So post-2022, I am challenging this is law.
Why?
Because your lordship, that power bringing of any other person, that is the wrong interpretation.
Okay,
It-
now come to the point. How can there be a state?
Your lordship, let me be very clear, yes, fear of legislation is not mandatory. But your lordship, when I was arguing the matter, when I demonstrated this court was of the view that yes, no further appointment has to be made in acting of this legislation. Let's leave it to your lordships.
I can't extend that. But what happens? Any appointment will be subject to the outcome.
Pardon,
Any appointment being made is subject to the outcome. Any appointment being made will be subject to the outcome of the PR.
my lord.
But the fact that the state cannot be governed, taking into account the separation.
No, your lordship will appreciate one fact. Your lordship will before your lordship, I bow down to you this honorable court. The question that which is of paramount importance is that since the validity of an act, the amendments have been raised in, if they are raising the maintainability of the issue, let it be decided on that first.
Which one?
If the state wants to say that this petition is not maintainable, let them raise it. Number one. Number two, because I am saying that
But
this,
Mr. Buragwai, am I not required to extend the interim order?
my lord, your lordship is required.
Which I am not.
Your lordship, in that case, your lordship, let there be no appointment at the present state.
No.
At the present state. Because
Any appointment happens shall be subject to outcome.
my lord, your lordship, they have not qualified.
Mr. Buragwai, the problem which arises is, however they have made that act, which I don't want to incorporate in my order now, is that there appears to be no violation to the Central Act. There appears to be no violation. It may go against the object, for which I have said it I've already asked the Advocate General to that effect. But the main problem which I see out here is, on one hand, you are making a lokayukta who is higher in the post, who can be a judge, Supreme Court judge, all these things, and even be a chief secretary. Whereas you are making a upalukayukta who can be a high court judge, which goes very much against the status,
Exactly.
the protocol. So this cannot happen like this. Now, the basic idea which you need to, when the final hearing may come, is on the point as regards the object, not on the object of this. The object is for the purpose of corruption, for the people to have faith in that institution. And to have a faith in the institution, the question is that therefore it is required that these are persons which should be there. Now the question is, a person of impeccable character. One thing you have to also take note of, a person who has an impeccable character or integrity and all these things need not always be a judicial officer or a person having knowledge of a judge of law. He may not be. Other person can also have it. But the question arises as to whether the faith in the institution will remain if it is not from the judicial background.
Exactly.
So that is the question which you may further
See, that's
argue
why
at a
we
later
have hope
stage,
to
but
the
I am
division.
not going to extend the interim order. That's we.
I rest it, your lordship, if my submission, that particular submission, that particular, because the issue is of paramount importance, if that submission is recorded, then let us take.
Absolutely. I really like recording everything. Don't worry. I haven't heard this. Because the moment I record more, anyways, let's see. Heard Mr. S. Boragoi, the learned counsel appearing on behalf of the petitioner, and Mr. K.G. Balagopal, the learned
Worship, assisted by
so-and-so,
Nityan appear.
appearing on behalf of the learned advocate general, assisted by so-and-so, appearing on behalf of the respondent number 1 and 2. It is seen that from the records that on 22/1/2025, this court had issued notice and till date, no affidavit has been filed on behalf of the state Mr. The Advocate General submits that the affidavit has already been prepared and would be filed in a quick, within a week or so. First, Mr. S. Purahuai, the learned counsel appearing on behalf of the petitioner, submits that there is an interim order has been passed, which have been extended from time to time. First, he therefore submits that it is required that this court should extend the interim order. First, we have heard the learned counsels appearing on behalf of the parties on the question of extension of the interim order. First, we take note of that the challenge made in the instant proceedings is to the Nagaland Lokayukta First Amendment Act 2019, whereby the Nagaland Lokayukta Act 2017 was amended. The challenge made in the instant proceedings is to the eligibility of the selection committee, the composition of the selection committee, as well as the eligibility of the Lokayukta.
The second amendment.
The
First amendment is with the selection committee comprising the chief secretary and the AG. The second amendment is of 2022, where any person.
Okay. Okay. We have taken note of that the challenge made in the instant proceedings pertains to the Nagaland Lokayukta bracket First Amendment Act 2019, as well as the Nagaland Lokayukta Second Amendment Act 2022. First, by the amending Act of 2019, the section 2, so the subsection 2 of section 3 was amended. First, by the amending Act of 2022, the eligibility of a person to be appointed as Lokayukta were changed by amending subsection 4 of section 3. First, it is relevant to take note of that these amendments so carried out to the Nagaland Lokayukta Act 2017 are amendments made by the state legislature. First, the learned counsel appearing on behalf of the petitioner submitted that the challenge made to the amending acts of 2019 and as well as the amending act of 2022 are on the ground that the said amending acts is in conflict with the Nagaland, the Lokpal and Lokayukta Act 2013. He submitted, for short, the Act of 2013. He submitted that the Act of 2013 was enacted by the Parliament by invoking the powers conferred in entry 12 of list 1 of the 7th schedule to the Constitution. And this very aspect of the matter can be very well seen from the objects, from the statement of objections reasons of the Act of 2013, as well as the very preamble of the Act of 2013. The learned counsel further submitted that by virtue of Section 63 of the Act of 2013, the state legislature have been empowered to make legislations for the state. And it is on the basis thereof the Nagaland Lokayukta Act 2017 was enacted. He therefore submitted that as the power which has been conferred upon the state legislature is on the basis of Section 63 of the Act of 2013, the Nagaland Lokayukta Act 2017 cannot be in conflict with the provisions of the Act of 2013. Anything else? Per contra, Mr. K.G. Balagopal, the learned Advocate General, submitted that a detailed affidavit is in the progress of being filed, is in the process of being filed. He, however, challenges the very maintainability of the instant petition on the ground that the instant petition which is done in the name of in the form of a public interest litigation is not maintainable. First, the learned Advocate General further submitted that these amendments were made in the year 2019 and 2000, as well as in 2022, is on account of the dearth of officers, the dearth of persons, on account of dearth of persons, on account of non-availability of the persons who could be appointed, on account of non-availability of Supreme Court judges of the Supreme Court, Chief Justice of the High Court, as well as Judge of the High Court. First, he further submitted that the Act of 2013 is silent as regards the eligibility of a Lokayukta. First, in addition to that, he also submitted that the selection committee for selecting the names to be referred to the search committee to select the names which are to be referred to the selection committee is also not in conflict with the Act of 2013, as the Act of 2013 mandates the search committee only for the post of Lokpal. The learned Advocate General also submitted that taking into account the separation of power between the executive, the legislature, and the judiciary, an act of the legislature, be it the principal act or an amending act, ought not to be stayed, cannot be stayed, ought not to be stayed till it is being found, till a finality is reached that the act in question is in violation to Article 13 of the Constitution, comma, ultra-virus to the central law, comma. What are the four I said?
Otherwise, to the legislative competence, madam.
And the state does not have the state legislature does not have the competence, as well as till as well as the said act was not made in accordance with the procedure established. He's therefore the learned advocate general therefore submitted that a question therefore does not arise. Therefore, this court ought not to extend the impugned order, extend the interim order. First, we have given an anxious consideration to the respective submissions. First, the law in the subject as regards the law as regards stay to an enactment of the legislature or its amendments made by the state legislature is very clear. Comma. On the basis of the separation of powers. Now, first, the power under Article 226 of the Constitution can be exercised when this court is of the opinion that the act the impugned enactment is ultra-vires the Constitution or ultra-vires the Central Act, or the state does not have the legislative competence. First, this finding can only be arrived at after hearing the matter and a finality and after this finding can only be arrived at the culmination of the instant proceedings. First, taking into account the principle, the doctrine of separation of powers between the executive, the legislature, as well as the judiciary, comma, in our opinion, it would not be proper to stay the proceeding, the amending acts of 2019 and 2022. First, this court, however, is of the opinion, this court, however, observes that if any appointment is made on the basis of, by taking into account on the basis of the amending act of 2019, as well as the amending act of 2022, the same shall be subject to the outcome of the present proceedings.
Just wanted to point out one point, my lord, where your lordship had said that the unavailability of Supreme Court, High Court judges. You may also add, my lord, towards the end, in the state of Nagaland. We don't have that.
Put it there.
Very well.
Advertisement can be done, so everybody can come and apply.
Very grateful.
You can fix a date for meetings.
Okay.
Well, as far as the affidavit is concerned, which I said is almost ready, I want to take into consideration the valuable inputs my lord has also suggested. I take it.
I never suggested.
I not suggested.
I never suggested.
I take it on me. I stand corrected.
Your submission which I have recorded.
I stand corrected, madam. So I was thinking that I may take a little more time to give a proper shape to the affidavit. That's all I'm saying.
Can we have it on 16th of April?
No, my lord, not in April in any event.
No,
though I'm coming to Nagaland. In fact, I may take about at least 2 to 3 weeks to finalize my affidavit.
Assam is a place where everything moves slowly. We never
my lord, I'll do this, my lord. Give me just 2-3 weeks. I will do it. I'll be grateful.
We'll have it on 7th of May.
Very well. Grateful.
7th of May. In the meantime, pleadings to be completed.
We'll do that.
May and Mr. Advocate General, you file your affidavit by 25th of April.
I'll do that. I'm grateful.
The affidavit be filed by the state on or before 25th of April 2024.
We'll do that.
Reasonable.
And
Reasonable.
petitioner herein, if so advised, would be at liberty to file a reply. Full stop. List the matter on 7th of May 2025. Full stop. Before parting, this court observed that taking into account that this court had not extended the interim order, the respondent authorities, the respondents shall file their affidavits on the date so fixed.
Obligement.
Deeply.
For orders, item number 9. Lordship, we have not been served till today. I am for respondent number 5. As per the last order, Lordship, order is in 26(3). This court has directed the respondent number 4 to officially communicate.
Wait. You wanted urgency, upgrading. Who wanted upgrading?
Lordship.
Why?
Lordship, basically, we have not been served. This is
That is not a case of upgrading. Give us the serial. You want an upgrading, there's something else, something heavens is going to fall in next 1 hour. Then we upgrade. We don't upgrade. Otherwise, the habeas corpus matters are there, which required not filing an affidavit. And anybody in the meantime file the affidavit, give a copy. By the time he can say, when a matter reaches, he can very well say, I've received the copy. Okay, now item number 3. What is this? Preventive detention.
Lordship,
Why detained?
Your Lordship, in this matter, Your Lordship, I kindly let it list next week, Your Lordship. In the meantime, I'll file my affidavit, Your Lordship. I've received the parawise comments.
You are inside from when?
For the last around 8 months, Your Honor. I pray that the matter may be disposed today. I'm inside bars for around 8 months as of today. 7 months, 20 days.
Why you have been put inside?
For alleged recovery of trucks from a car that we were sitting in the. For the alleged recovery of trucks from the vehicle that I was seated.
You were caught red-handed.
There were 3 of us.
As per the allegation. As per the allegation, you were caught red-handed.
Yes, Your Honor.
Okay. Now they have put you under preventive detention.
Yes, Your Honor.
Why?
For the allegation of recovery of trucks.
That is you are already there.
Yes, Your Honor.
Why is it required?
One of the ground that they have stated is to, which is there in my annexure. 4. One of the reason that they have mentioned is, now therefore, page number 33.
Let
Your Honor.
us see the order of
Page number 33.
Special Secretary to the Government of India. Isn't he the authority? The detaining authority is who?
Here is Sonia Singh, the Special Secretary to the Government of Bangladesh.
Sonia Singh will be the what authority? Whereas I, Sonia Singh, so and so specially empowered under Iman, I am satisfied on careful examination of the proposal and other documents found sufficient grounds for detention of Iman and being satisfied in view of the preventing him from engaging in so and so, detained in so and so. You are inside?
Yes, Your Honor.
What is wrong with your government? How many orders every time I come up and pass this type of similar orders? What is wrong? He's inside. Drugs, commercial.
Yes, Your Honor.
Then 180. 180 plus again, you may ask for another 180 days. Then what was it? And you were arrested when?
10th of July 2024.
10th of?
July 2024.
10th of August.
July 2024.
And they passed the detention order when?
On a
17th August. Why is it necessary? At that point of time, he was to be enlarged on bail? There's nothing, not a single word out there.
Your Lordship, to ably assist the court, I may be allowed to file an affidavit, Lord, and it may be taken up next week for disposal, Your Lordship.
Your Honor.
I've already received the parawise.
Saturday, Sunday, I have no work out here. So we can have it on this Friday and finish it off.
Your Lordship,
And you deliver the judgment on Monday?
Monday, Your Lordship, please, Your Lordship, because
This type of, madam, you have to understand. These are preventive detention matters.
Your Lordship, I understand. That's
I'll
why,
pass the
Your Lordship,
order on Friday itself in the court. This type of orders is, how is it possible? My goodness. How many judgments we have delivered?
Your Honor, in this case, I have not been served the detention grounds till date.
that's
What
just-
grounds?
The grounds of detention,
Your
I have not
Lordship,
been served,
That's their submission,
which
Your
is the
Lordship.
fundamental.
Okay, I think we
That is
should
their
impose
submission.
some cost.
Your
upon-
Lordship, that is their submission, Your Lordship. The fact is, that's not a fact, Your Lordship. The records will show that he was,
Why you not brought the records? This was filed on when? 27/2/2025. We are in the month of April. 1 day delay is very dangerous. Goodness. Issue notice.
Your Lordship would also take note that the service copy was served to me only on the third day, Your Lordship. And only after that I was able to serve a copy to the government, Your Lordship. They had served me a cops, the service copy only on the third day of after filing the affidavit, the
30th of
writ petition. No, on the third day of filing of this writ petition, Your Lordship. So only on the third day only I was able to serve a copy, Your Lordship. And there was a holiday as well, Your Lordship.
Filing was done on 27th and it was moved on the 3rd.
And
After
they have served me a copy only on 6th,
Yes,
extra copies, Your Lordship.
fair enough.
So, Your Lordship, I'm
6th,
just
and
seeking
then what is
for,
happening?
Your Lordship.
6 after 6, what is happening? Nothing of this.
Your Lordship, I have already received the records as well, Your Lordship. Monday, Your Lordship, may be listed on Monday, Your Lordship, so that I can file an affidavit.
No, not possible. Friday.
Okay.
Friday, these matters you have to file it, well, bring down the records. We don't require the affidavit, bring the records. Bring the records on Friday, we dispose it on Friday.
Your Lordship, without the
Right.
affidavit,
You don't file, that is your lookout. I can't pressurize you to file an affidavit. It is your lookout. Person in preventive detention every day. You see, 7 days delay is considered to be means fatal, isn't it? If you don't give the detention grounds within 4 days, within 24 hours or some hours out there, it is considered to be fatal. And now we are considered that this fellow is languishing out there in the jail under FOSIA. He has not got the bail under 37 also in view of that. You
Your
got the
Honor,
bail?
No, I've moved to bail under default and before the special judge Timapur. However, the order has not been passed because this order is yet to be,
You have gone for default bail.
oh my lord, it's not been considered till now.
They have not taken any action. Why? If they cannot submit the charge sheet by then, well, there's another very recent judgment of Justice Dhulia. Have you read it? Here is a case where a bail was granted. Thereafter, he was put under preventive detention. The Supreme Court said that to you. If the bail was granted for whatever reason, then why do you require his detention? And as on that date, the detention order was bad. Because at that point of time, there was no supposed to be on, you were not supposed, you did not apply for bail. Did you apply for bail?
Yes, Your Honor, I've applied.
When?
I forgot the date. However, I've applied before the special judge Timapur. But because of this detention order was passed.
No, that you applied subsequently for default bail. Not at that point of time, on 17/8, did you apply?
No,
And then there was this problem of section 36 coming into play. Okay, Friday, get your records.
For admission,
And
item
get-
number 4.
Mr. Counsel, get 1-2 judgments which I have delivered. Without judgment, he is inside again. Is the matter on Friday, on which state Ms. so and so shall apply, shall produce the records. Yes, what is this?
Yes, please, Your Lordship. Lordship, headless corpus matter. Another headless corpus matter, one. And another PNDPS. Absolutely illegal.
Why is nobody appearing? Who is appearing? You?
My lord, my colleague is appearing. He's coming.
Who?
Who is the moment?
Where is he? When were you inside, Mr. Viti?
Lordship, detention order was passed on 4th of February.
this foot.
for February. And then
And you were
I was
arrested.
arrested and in custody since 7th of September 2024.
Why it was passed?
Lordship, may kindly come to page 35, the grounds of detention. The grounds of detention only.
Every time it is same.
Lordship, may kindly see the grounds of detention. The relevant portion, my lord. I'll just take your lordship to one paragraph only, page 36. Page 36, paragraph number 6. The reason for passing this order. That you are presently under judicial custody. On the basis of material placed before me, I am satisfied that you are likely to indulge in similar prejudicial activity unless you are prevented from doing so by an appropriate order of preventive detention. It doesn't say, my lord, doesn't say that you are likely to be released on bail, but it implies that I'm going to be released on bail and therefore I need to be detained. Lordship?
No, one is there.
Yeah.
First of all, it is these people, if they don't file their charge sheet,
Lordship.
you have not filed the charge sheet. Why?
Now, Lordship, my bail was rejected before this order was passed. That has not been considered. Supreme Court cases, my lords, judgment in the other, I think it's Nancy something case, my lord, in last year. Those details, the requirement when a person in custody.
This morning only I filed my affidavit in opposition.
Oh, you filed?
He lodged
That's good, my lord.
this morning.
Oh, fantastic.
This morning.
At last. Produce the records on Friday.
Lordship, if this matter can come up on Monday, Lordship, since on Friday I have some re-engagement.
Okay, ask some other council. Pay 50,000 per day cost. In Gauhati, I impose this type of cost because the person's liberty is a question. Huh?
Lordship, on Friday.
Right.
Lordship, can it be tomorrow, my lord?
Tomorrow, no. We have other matters. Huh?
Lordship,
I filed this morning only and I've sent the copy to the.
and trial matter has been fixed for evidence on Friday. That is the only problem.
Huh?
And matter, my trial evidence has been fixed for Friday. That's why, Lordship, tomorrow.
I can't help you then. Because next week there will be a division bench throughout. Well, let him come up on Monday.
Monday.
Lordship.
Obliged.
It's the man. An affidavit has been filed by the state in the instant proceedings. Today, no?
Today.
Today. The same affidavits have not been brought on record. It's the Longgen, the learned counsel appearing on behalf of the petitioner submits that taking into account that this is a preventive detention matter, the matter be listed again on Monday. Be listed at the earliest. Taking into account the above, list this matter on Monday, date to deliver, on which date Mr. V.G. Momi shall produce the reports. But unfortunately, I may not be sitting on Monday in the division.
For
That is
admission.
why I fixed the earlier matter on Thursday, Friday, so that the matter goes. Tomorrow not possible. Yeah. Because I have to dictate that order. Because there is a likelihood.
Yes.
For admission, item numbers 5 and 6.
Yeah, we got the records.
Yes, Your Lordship.
Chala. Let's do something good today. Yes, what is it?
May please your lordships.
Same FIR.
Why you have been detained?
On the allegations that I've been in possession of 1.259 grams of heroin, my lord.
What?
I've been arrested for possession
Of
259 grams of heroin, my lord, or suspected heroins
And when were you arrested?
on 23/05/2024.
Huh?
23/05/2024.
Yes.
23/05/2024. And thereafter, the detention order was passed on 9 July 2024, madam.
Where are my orders? Let me dispose of these.
Yes, my lord. I have with me.
The one with the song?
Yes, my lord.
Is
This is the one.
song?
Yes, my lord.
Ah, yes. And what about the other one?
Your lordship is from the same FIR, your lordship.
Huh? Same.
Same.
Both of you are there on this 1.25.
Yes, my lord.
Both
That is,
had
that is the
1.25.
allegation, my lord.
You are there for the other one.
Lord, I'm arrested on 24/5 based on the statement of the co-accused. I was not there at the time of the arrest of the other accused who were in the possession of the drugs. I was just arrested based on the statement of the other accused.
Chalo. Okay. Judgment reserved. Pass on.
Please, my lord.
Get the order by tomorrow. What is that? Rekha. Amina Begum is the right now. Isn't it? Hello? Pass the order.
So push the, put the pitch mark in, lordship. Pitch
Huh?
mark on the orders, your lordship.
Okay.
On the
We'll have a look at it and pass the order.
For admission, item number 7.
Yes, what are you challenging?
Lordship, if the matter can be taken up next week, my lord. I want to place some citations, but
You have taken so much of time for getting a matter admitted. In the month of June 2024, I granted you an adjournment.
my lord, my lord.
So people will laugh. What is wrong with this court? It has to be either admitted or dismissed. What do you think? What is it challenging?
I am challenging the single bench decision, lordship. Impugned judgment and order dated 27/6/2023, lordship. Which I have annexed pages 69 to 86, lordship.
What do you want? Regularization.
Yes, lordship.
Service
served
of the
the
petitioner
department for-
against the lowest pay scale permissible for remand in the PHC for grant of pensionary benefits to the petitioner. You're retired?
Yes, lordship, I have retired.
How is it possible to regularize you now?
Yes, lordship. In other similarly situated cases also, lordship, similar direction has been given, lordship.
The Supreme Court has all negative those judgments.
Lordship, in fact, lordship, there is a division bench decision, lordship, passed by this honorable court, in which my Lord Justice Takia was also part of, lordship. That has come to appeal before the Supreme Court. Supreme Court has upheld the division bench decision of this honorable court.
Regarding, but there is another judgment of the Supreme Court. It cannot be done. This is MR Shah's judgment on this aspect only.
MR Shah, lordship.
How can you give it by one day regularize you means it has to be regularized
Yes,
backdated?
lordship, that is posthumous regularization, lordship.
How is
Yes.
it possible?
Now, the same judge.
Yes, it would have been permissible if you were entitled at that point of time under the scheme and that was being deprived. Were you entitled at that point of time under any scheme and you were deprived, then the question would have arisen.
Lordship,
You have these two.
yes, lordship. Yes,
One
lordship.
is for the work charge under the
my lord. Yes.
2004 one, and the other is the 2015.
Yes, lordship.
Do you come in any of them?
Lordship, the law, lordship, as to my understanding, laid down by the Honorable Supreme Court, lordship, is that, lordship, once a work charge employee serves for 30 to 40 years, lordship, which is 35 years in my case, that is the maximum number of years which I can serve the government in Nagaland state, lordship. Under such circumstances, lordship, then the government, the work charge employee, he is entitled to regularization, lordship. In fact, lordship, there is another MR Shah decision wherein the employee has served for 30 years, lordship, and regularization was directed, lordship. But in this case, lordship, that is also a case which has arisen from the state of Nagaland. In that case, lordship, the employee, lordship, he was not entitled when he died, lordship, in harness. And the wife, he approached the High Court for the first time after a delay of 12 years, lordship. On those two grounds, lordship. And lordship.
No, therefore, my question.
Yes.
Were you entitled under those two schemes? If
Lordship.
you were entitled to those two schemes, then obviously, then the question would have been given for not on the basis of you are entitled to regularization. After that, it is not the question. It is the question that you were deprived at that point of time for which regularization
Yes, lordship.
should be
Yes,
granted.
yes, lordship.
That is a different aspect.
Yes, lordship, because
But is it your challenge to that effect?
lordship, because lordship, similarly situated employees, lordship, and in fact, employees who were very much junior to me also have also been given the benefit, lordship, of regularization. But that same benefit was not extended to me, lordship.
It is required to be noted that the deceased employee died in 2005, and so considering the ratio in Lember versus and so.
The division bench decision on which I am relying on has already discussed at length, lordship, the decision passed in Nishiki's case also, lordship. And because that raised that issue, and it did not find favor.
Huh? Let's see your facts, what are they?
The facts, Lordship, are simple. He was appointed on 23/5/1984, Lordship.
Release from service on superannuation in 2019.
As work charge employee, Lordship. Kalasi. In the fixed scale of pay of rupees 300, Lordship. He was awarded, Lordship, a fixed scale of pay.
But why did you wake up so late?
I have,
You retired in the year 2019.
yes, Lordship.
Why did you wake up so
Yes,
late? In
I have in fact made a series of requests, Lordship, because
No?
I am a person who is hardly able to append my signature, Lordship. So verbal requests have been made time and again, Lordship, and the department told me, Lordship, that my regularization is under process and it is being
So
considered.
what is
Lordship.
their stand as regards your entitlement as per the 2015 scheme?
They are
Because
saying that,
if you
Lordship,
were appointed as a work charge,
Yes,
obviously you would be entitled to as per the fixed scheme,
Yes.
as per the 2015.
if I am receiving scale of pay, Lordship, then, Lordship, I
Or
mean
you
that
were not given a scale.
I have been awarded fixed scale of pay, Lordship, as is reflected in my appointment order, Lordship.
So
which I
without a
pen-
scale of pay, then you are not getting 15 benefit. Without a scale of pay, you don't
No,
get the
Lordship,
15
no,
benefit.
Lordship. And Lordship,
So then there will be the question of vacancy having arisen then, whether there was vacancy there.
as per the scheme, Lordship, as per the scheme, the
Let's go as per the 2004.
2004 as well as 2015, yes.
2015 does not happen because you were not granted a scale of pay.
Lordship, as per my appointment order, I am awarded scale of pay, but my scale of pay is fixed. As is clearly reflected in the appointment order. My appointment order, I have annexed, Lordship.
Yes.
Annexure 1, Lordship, at page 60.
Page?
60, my lord. 60.
Yes.
In the first line itself, Lordship, 18 of us were appointed. So, in the interest of public service, the following persons are hereby appointed as work charge Kalasi in the scale of pay, Lordship. Rupees 300 under bracket fixed, Lordship. So 2015 notification says that if I am receiving scale of pay, Lordship, and if I have served for 30 years, Lordship, then I am entitled to regularization.
And you also say that there were 380 employees who were junior to you have been regularized.
Yes. 195.
That means
in
there,
fact. 195.
So that means there were certain junior
Yes, Lordship.
who were having a fixed scale. Fixed scale?
Yes, Lordship.
They were regularized.
Yes, Lordship.
And you were not granted.
No, Lordship, I was not. I have annexed the RTI application also in my petition, Lordship.
Yes, Mr. Sagi.
Lordship, and for the Accountant General Office here, I have nothing to say. my lord.
My lord, here, your lordship rightly pointed that 2015 OM is not, the petitioner is not covered under 2015 because here he has been appointed on fixed pay. So in the 2015, it says that those who are enjoying scale of pay. So as per the 2015, the villain is not eligible. Secondly, that the ground which he is raising now is that some of his juniors have been considered. My lord, that though even if it was considered or not, what he was doing during that time, only after the retirement from the service, only he is raising this question, my lord. During when he was in the service, when his juniors were regularized,
He was silent. Petition, the villain was silent.
Don't you think he has a case for admission?
No, my lord. Because that honorable single page has clearly stated that.
Very well, that's a
Yes.
different thing. But the fact remains as to whether there is one thing, the question of regularization cannot be directed by the court. There's no quarrel, but recently there are two judgments which have come of Justice Vikramnath, wherein he says that you cannot take the judgment of Uma Devi in such a manner that thereby depriving those persons concerned who have worked and rendered service for all this while and not to give. That is one aspect. But the other aspect is, if he have been not granted the benefit of the 2004 OM and somebody else have been done so, we are not setting aside the others. But the fact remains, if he have been deprived of that, if there was a vacancy which have arisen then don't you think that he has a right to claim his rights under Article 14? Normally a person, this court cannot grant a regularization, there's no question. But if a scheme is there and the scheme is not followed and an inequality arises, don't you think that it is a case of a violation of Article 14?
Then, my lord, then in that case, the Nisivi case will cover govern his case, because in that Nisivi case,
No,
the
Nisivi's case had two aspects.
yes, though the
First, he did not qualify as per the scheme.
in
Secondly, during his lifetime,
yeah,
that person never did anything.
yes,
It is only after that his wife came up and did this thing.
Yes.
So this was the case of Nisivi.
yes.
But the fact that here he may have been entitled or not is a question which have not been dealt with by the single judge.
My lord, in that Nisivi case, the Nisivi husband served for 24 years.
Huh?
24 years.
So he didn't get it as
The petitioner's wife approached the court after 13 years. So on that two ground, during that when the Nisivi husband was in service, never approached before the authority. In Nisivi was enjoying the scale of pay and completed only 24 years. So
he was not entitled as per the 30 years thing.
yes, but 2004 OM he was eligible under the 2004.
No. For being eligible under the 2004 is the question of vacancy.
Yes, my lord. It
See,
is a seniority come merit.
Huh?
It considered on the basis of seniority come merit.
Seniority come merit is
Yes.
one. The second is on the question of vacancy. If there is a vacancy, they will withdraw.
Yeah.
And the second factor is 50%.
Yes, my lord.
The 50% which was there, and the 2015 made it more, 67%. And then it was reduced to again 50%. So that is another aspect of 2004. But as regards the 2015, it is not on the question of vacancy. It creates a right on him on having been a scale of pay and having 30 years. Now in Nisivi's case, he had 24 years in scale of pay, so he was not entitled as per the 15 Act.
Yes.
Now, as regards the 2004 Act, as to whether the vacancies arose is not a question before that in the Nisivi's case. So, don't you think that it's a case of admission at least?
My lord.
When he has been fighting, asking from every court an adjournment to escape a dismissal?
No, my lord. But your lordship is well aware that there is two office memorandum, 2004 and 15. 2015 is not covered by the 2015 is not covered by petitioner case. And even the 2004 also, it is since the case is considered basing on the seniority come merit, so might be in during his life in service, his seniority
It's
possession.
not seniority come merit, it is seniority.
Seniority come merit.
Is it
Yes.
2014?
2004 is seniority come merit.
2004, is it seniority or seniority come merit?
Seniority
See,
come merit.
let's see that.
I have to check, Lordship.
Where is it? 2004 is where? Where is the 2004? No. No 2004. Oh, your entire case is on 2004 and you have no 2004 here. Mr. Counsel? Can't help you. The entire case is on 2004. Otherwise, NICV is dangerous for you. Your only case is of 2000. And if you have not made out your case on 2004, nothing remains. Your case was not on 2004.
Lordship,
Mr. Counsel.
Lordship, my appointment order clearly states that Lordship, I aim to be paid scale of pay, Lordship.
Kindly understand.
Yes, Lordship.
That argument would not hold water before us.
Lordship.
Don't make that submission. You may have a case of 2004.
Lordship.
But your case is not made out of 2004. You have to make your case. Your basic, you had the base, but you did not apply it in a proper manner. You went on a 2015. 2015 does not come into the case. 2004 is your case. You do one thing, file an additional affidavit.
Lordship.
Take out what I have stated.
Lordship.
Bring it out and bring in.
Lordship.
That this is a fact in it. And say why you have not approved for 2 years.
Lordship.
Say on the ground that you were not. See, normally a work charge employee or anything who is getting 200, how much you were getting at the time of retirement?
Lordship, I have to.
Anyways,
Lordship.
whatever, he is not supposed to know many things. You have to understand that aspect also. You
Lordship.
cannot apply it in that manner.
Lordship.
You file an additional affidavit, bringing on record, on aspect this,
Lordship.
prove your readings on this, on
Lordship.
2004.
I'll file it within the course of the week.
Huh?
I'll
Yeah.
file it within the course of the week.
Mr. Sentian.
May I please, Lordship, since you are giving liberty to file additional affidavit, my lord, in the writ petition, that he has not taken the plea, yes, because in the 2015 only he was bringing relief, my lord.
Mr. Counsel, tell me, what is the power under 226? To whom the power has been given?
Court, my lord.
Which court?
Writ court.
To the High Court.
Yes.
The High Court, on its own, either be a single judge, division bench, or 3 judges. They can exercise jurisdiction of writ, isn't it? If he can exercise the jurisdiction of writ before the single judge, if something happens, that aspect is being not there. But if the division bench is also, the moment an appeal is brought before this court, the list which is there is brought before the division bench. If it is before the division bench can, in a question where the interest of justice mandates, can pass appropriate orders to the effect. Don't you think? Because they didn't say that it is the single judge. Can you say that the power which is being given under 226(1) can be restricted by the High Court rules? No.
Then, my lord, I may allow to file reply.
Let him file.
It's additional, yes, ma'am.
Let him file. We'll see.
My lord.
You may say that, okay, his affidavit is in such a manner he has filed that we don't require anything to file. You may always take the help of NICV.
Yes.
My lord.
Mr. Santiago, the learned counsel appearing on behalf of the appellant during the course of the hearing submits that he would like to file an additional affidavit in the instant appeal, in the instant intra-court appeal, taking into account that on account of taking into account that a vital aspect pertaining to the rights of the petitioner was excluded while filing the writ petition.
My lord.
Was leave granted to the petitioner, appellant, to file the affidavit.
Much obliged, Lord.
Least the matter when you are the main person who is going to file. After that, he will ask for reply.
After a week, my lord, or after 2 weeks, lordship.
Okay, list the matter again on 23rd of April 2025. In the
Much obliged,
meantime, the affidavit be filed by 17th of April.
My lord, my lord. Much obliged.
Much obliged. For admission, item number 8.
Mr. Sanyanga, kindly look into one of my judgments delivered in the case of the state of Mizoram versus another case.
Lordship.
Recently delivered, I think it is reported everywhere. So what happened there, the single judge did not pass an order or pass an order asking the parties to go back to the district collector.
My lord.
Although held that these persons were entitled to the amount,
Lordship.
but the direction was not given to the state to make the payment.
Lordship.
Now what happened? This direction, which was, or the observations which were made to the effect that these persons were entitled, were challenged by the state of Mizoram.
Lordship.
But there was no corresponding writ appeal
Well,
filed by the other side, whereby they have been said that they have an alternative remedy, so they have to go to the district deputy commissioner.
Lordship.
So the matter came up before us. So the division bench, we passed an order to that effect how the intra-court appeal, because this is an intra-court appeal. This
Lordship.
is not an appeal. You have to understand, this is an intra-court appeal. It's a mechanism made by the rules
Lordship.
by which the exercise of jurisdiction which is being made by the single judge is being exercised by the division bench. It's the same jurisdiction we are exercising. We are not exercising a different jurisdiction.
Lordship.
Unlike, just for example, in a CPC, the trial court exercises the jurisdiction, and then the appellate court who exercises the jurisdiction is an appellate court, which is by a statute.
Yes, Lordship.
Here, the power is given under 226(1)
Yes, Lordship.
to the High Court. How the High Court exercises in between them, therefore it is said to be an intra. Read that, sir.
Lordship.
Lordship,
Is it a 2025 decision?
Huh?
Is it a 2025 decision, Lordship?
Yes, yes. Recently, it has been reported out there. I delivered the judgment on 16th of November
My lord.
in the of the Mizoram bench. Yeah, so I think it will be reported in 2025 for one.
My lord, my lord.
So therefore, the Supreme Court once what happened, the matter, the Supreme Court, the division bench of one High Court remanded the matter to the single judge. The Supreme Court says that division bench cannot remand.
Okay.
The reason why it cannot remand, except if it is dismissed on the question of, just for example, you file a writ petition, I dismiss it today,
Lordship.
and your writ petition is not maintainable. But if I hold tomorrow, the division bench holds, no, he has a case, then I have to remand it by holding that, setting aside the judgment and holding it, yes, you have a case for entertainment, so that an opportunity can be given to him to file his reply.
My lord.
That is the basis for it. But otherwise, on merits, you cannot remand. The division bench cannot remand to the single bench
Lordship. Lordship.
because it is exercising the same
Yes,
jurisdiction.
Lordship. Lordship.
Because the exercise of jurisdiction is like a latest patent.
Much obliged.
May I please, Lordship?
Hmm?
My lord, here I'm mentioning on behalf of S. Mary. My lord, let the matter become up after 1 week, my lord.
What is
Item
the
number
case?
8, item number 8, my lord.
What is the case about?
Lordship, this is a case of premature release, Lordship.
Premature?
Premature release.
Of?
Lordship of a convict, Lordship. He has already served more than 14 years, Lordship. Now, in 2001, the government of Nagaland came out with a notification for releasing life imprisonment convicts, Lordship. Now, under that, I was eligible. So last year, I filed a criminal petition praying before this honorable court, Lordship, to dispose my representation. Lordship, meantime, the state government came out with the new notification, a new policy. Under that, Lordship, I am no longer eligible. So, Lordship, the issue before this, in this case, Lordship, is that whether the first notification, which was applicable when I was convicted, whether should it be applicable or the 2024 notification should be applicable, Lordship. Lordship, this issue has already been well decided, Lordship.
By?
The Honorable Supreme Court, Lordship.
Then?
They have categorically stated that the policy which was existing when I was convicted, it should be made applicable.
So your representation has not been considered?
No.
And now in view of the amended this thing, the policy, you
Yes,
don't
Lordship.
come within it.
Yes, Lordship.
And how many years you are there? And why haven't no affidavit filed?
More than 14 years, Lordship.
Why you are not filing an affidavit? This is a matter, long matter, 18 to 19 to 2025. I think we should impose a cost of 20,000 upon you.
My lord, here,
No,
my colleague
20,000.
S. Mary is appearing, my lord.
No,
The matter will
let-
come up next week, my lord.
Now 20,000, next week I'm sitting again, I'll put another 20.
No, my lord.
No. Isn't it?
Next week, my lord.
So today 20,000, next week 20,000. Not done. How can you? A person is inside. He has a right. He has a legitimate expectation that you will be considering his application. Anyways.
Lordship, due to some personal emergency, S. Mary left, Lordship. Otherwise, she was ready to take up the matter, Lordship.
Huh?
S. Mary, due to some personal urgency, she left, Lordship, today. Otherwise, she was ready to take up the matter, Lordship.
Chalo. Okay. So you don't want the cost.
That to be fair, Lordship.
Okay. Mr. So-and-so appearing on behalf of S. Mary, the learned counsel appearing on behalf of the respondents, submits that the said counsel who have been entrusted with the matter have to leave the court due to personal difficulties. He therefore submits that the matter be listed tomorrow, next week. First, this court have also taken note of the matter in question, wherein the petitioner, after having already served a period of more than 14 years imprisonment, isn't it?
Yes, Lordship.
Have sought for release
He has been
and submitted,
custody
and in
from-
that regard had submitted representation. But sir, the said representation have not been considered.
Yes, Lordship.
In addition to that, there is also a communication being issued whereby the rights of the petitioners to premature release have been affected. And as such, the said communication is also put to challenge. It is noticed that the instant petition was filed on 18/2/2025 and notice was issued on 19/2/2025. And the state government have not filed an affidavit. It is relevant to take note of that we are considering a case where a person is seeking his rights under Article 21 of the Constitution. First, delay in disposal of such matters affects the delay in such matters, affects the administration of justice, as well as the rights of the convict. This court fixes this matter again on 9th of April 2025. The state government shall file the affidavit on or before the next date.
Much obliged.
Much obliged.
Others, item number 9.
As per the last order, we have communicated the course order to the respondent number 5, that is the insurance company.
Kind of Wakalatama today on behalf of respondent number 5.
Wait, you have an urgency. You are the respondent number 5. What is this matter about? Yes, what is the matter about?
Lordship, this matter pertains to the implementation of the Ayushman Bharat scheme in the state of Nagaland, as well as the convergence scheme called the CMHIS. So the CMHIS and the Ayushman Bharat. So under this, there are list of empaneled hospitals along with beneficiaries who can avail those schemes in terms of free health delivery services in the public sector, private hospitals, and as well as the government hospitals as well. So Lordship, what has
Wait. So he has appeared for the first time.
he's appearing for the first time in Lordship.
So he has a right to file his affidavit.
Lordship, that can be done, but however, despite that, the urgency in this matter is because the insurance company have now, which is the respondent number 6 in this 5, apologize, Lordship. Since last year, what has happened is they have stopped paying the claims of all the hospitals across the state of Nagaland, despite the state respondent, as per their claim, paying the premium to which the insurance company have been receiving till date. So the state agency pays the premium to the insurance company. Insurance company in return gives the claims of the hospital to the services being given to the public in general. So the insurance company now on claims of fraud, those are just claims, Your Lordship. Nothing has been ascertained so far as per records, whatever we have. But on claims of fraud itself, they have stopped mechanically and uniformly stopped paying all of the claims to
Yes,
the private.
Mr. Moju, what is your stand?
Yes, Lordship. I represent the Nagaland Health Protection Society. Now we are the agency who implements these 2 schemes, Lordship. Now, as per the contract agreement, we are supposed to pay the premium to the insurance company in 3 installments. We have paid 100% the premium.
But they are not honoring.
They are not honoring. Now, Lordship, the pending due has gone up to 44 crore. Hospitals are suffering. They are on the verge of collapse, Lordship. Now we have been threatened that we will discontinue with the service. But because of the intervention of this Honorable Court in this PIL, they are giving the service.
These are private hospitals.
They are private hospitals. Now, Lordship, I would like to place a Lordship. I'll try an affidavit to that effect, Lordship.
No. Wait. Yes, wait. Why have you appeared so late?
As per the order dated 26 March, Lordship, there was a specific direction and recorded that we have not been officially served till today. And Lordship, today also we have not been served as per the direction issued by this court to respondent number 4. He has intimated us, and on the basis of said intimation, I am appearing today, Lordship. I have not received a copy of the PL so far.
Lordship, we have already sent it through the registry.
She can serve me right now.
Madam,
Lordship.
all these things, let us not go into these small intricacies. You take a copy, give it to him. This is the PL copy?
Yes, Lord.
Give it to him. You give another copy. You are outstation.
Gauhati, Lordship.
Madam, you do one thing. You give him a copy now. Okay. So and so. Mr. So-and-so appears on behalf of the respondent.
Asking for the notification, the vacation of the interim order dated 14/2/2025.
You have filed an IA?
Yes, Your Lordship.
No, Lordship, the contract has expired on 31st March. The contract period has expired,
Which should
31st March,
with
with the private hospitals. Because for the new financial year, now, Lordship, because of this issue of non-release of the claim of the hospital by the insurance company, we have converted into trust mode for 1 month till a new insurance company comes in, Lordship. Now, if they give service, the government will pay them is through the trust mode. Previously, we were in the insurance mode, Lordship. Now, Lordship, the issue is not that we have not communicated. Now they have raised fraudulent cases on the
No,
period.
no. So, Mr. Mojuin, now the contract with the government with them is
Yes.
no longer there
Yes,
as of now.
yes,
So as of 31st of March, the contract is ceased.
yes, Lordship.
Now, if it is ceased, now if they are to give service, if they are to give service,
After the second,
so
it
they,
will be in a trust mode.
so there has to be some other mode done by you,
Yes, that is a trust mode. We have done for the second.
so which you will have to do.
Yes, we are doing. We are doing.
So for that, you may have another insurance company.
Yes,
Now, if they have not paid,
Lordship.
for that, they have the people have now already got their benefit.
Yes,
Now, amount of 44 crores have accrued,
from there.
which they are to pay to the.
It will go out. It will go out because the claim they have not cleared.
Understood. So whatever may be 44 or 50 or 60,
Yes,
whatever may be, they are to pay to them.
yes,
They are to pay to them
yes,
at the behest of a contract entered into between you and him.
yes, Lord.
Now, isn't it a dispute between you, him, and him? And what does the petitioner have to
We
do?
have a separate agreement with the state, not with the insurance company.
Understood, but anyways, you are going to realize from the state. The state have, or to indemnify that,
Yes,
have brought in the insurance company.
yes,
So all you three are the main persons.
yes,
Now, as of now, the petitioner herein have already got it.
as per the contract agreement, yes, sorry.
They've got it.
Yes,
So in this PL, what remains? Why should we have a PL between a fight between you three?
Because we actually want to stop the service because without payment, our institutions will die. And once the private hospitals become.
No, you don't. You want to solve the servants' bits. What is the interim order passed? Let's see.
42.
Huh?
I have tried
14 to 2025. What is the interim part?
Then the private hospital should continue.
And in the letter written by respondent number 6 says remain stayed, and accordingly the respondent number so and so are directed to continue providing Iman until the returnable date.
And it was extended in the last.
Okay, I'm not extending it. Now, the question of
Hello.
extending, no, I can't extend it today because of the fact
Yes,
that they don't have a contract with you now.
yes,
How can I extend this?
yes,
If the contract has come to an end on 31st of March,
Yes.
with them also,
yes, Lord.
you are the state has to pay.
Not the state, Lord.
You don't have a contract beyond 31st with them.
Yes, Lordship, but the claims are before 31st March.
Understood. So therefore, it is a claim vis-a-vis the state has to take up with the future generally.
We have already taken up. They are not
So
responding.
if you are not, so why you are bringing, is the PL file at your behest by her? Is the PL filed at your behest by her?
No, Lordship.
Lordship,
The issue was raised by the petitioner for discontinuation of service. That was the contention,
Understood. Now the petitioner has already got it.
Lordship.
Now, whether Ayushman Bharat, the petitioner has a right because that's a central government scheme.
Yes,
So Ayushman Bharat is there. Now, if the state government has announced a scheme, then they look here, till 5 lakhs or 10 lakhs, we are going to give benefit. Petitioner has a right to ask you. And if you don't give it, then she has a right to
yes,
evade the remedies
that
under
is,
law.
yes.
But in this case, is there any dispute today as of now that the petitioners can claim against you? Only you, not against them. They are nobody. Or future generally has nobody. The petitioner is claiming with you on the basis of that you have a scheme. Isn't it?
Lordship,
Have you discontinued the scheme?
no, Lordship.
So the petitioner has a scheme, but what is the business with it, within the relation of three of you? Petitioner is not concerned,
Yes, no, Lordship, yes.
isn't it, madam?
Lordship.
You are only concerned to get the benefits under the scheme.
And the public should not suffer
No,
because of the. turmoil,
Understood,
Lordship.
everything understood. But for that, you have no business with future generally. Whether they give or not, how does it matter? The state government has come up with a scheme that we are going to give you 5 lakh rupees benefit or whatever may be, 10 lakh benefits or whatever may be. The state government. So you are claiming that he has a policy that but we are not getting the benefit. So you are asking a writ.
Lordship.
That's it.
Lordship.
But on the other hand, what is being done out here is a fight between these three. It's a fight because the state has a fight with the future generation.
Lordship,
The
definitely.
state, he is not paying him. And now because their fight is a different fight altogether, we are not concerned to that effect.
Lordship.
The state has the muscle power to take against them, shut off their offices.
Lordship, we have gone even to the extent. And the matter is with the IRDA and the NHA.
So they will take whatever actions. But your case simple is that you should be continuing to get benefit.
Lordship.
But we cannot direct the respondent number 6 to serve unless the state has some relation with them. It is the state who has to do it.
Lordship, this was also filed on urgency basis because of the fact that they came up with a press release stating that by 15th February, overnight they will stop the services altogether. Out of sheer concern, because if that happens, Your Lordship, there are already beneficiaries who are admitted in the hospital availing services because of the Ayushman card, which has largely helped.
But Ayushman Bharat is a central government scheme.
Your Lordship, along with it here in the state of Nagaland, what has
State is implementing. Who is paying?
The government.
Then
Your Lordship, just
And the
for
premium has been paid to the insurance company.
I'm not concerned with that, whether they have paid or not. But it's a central government scheme. What
Yes.
is the central government stand?
Your Lordship, Ayushman Plus in the state of Nagaland, it's a very, again, a very separate model called the Chief Minister Health Insurance Scheme as well. So Ayushman Bharat scheme has been converged with the CMHIS. So the CMHIS covers the employees and the pensioners as well. And plus the Ayushman Bharat covers the general population who have not been under the government service. So that is a totally a different model that has been adapted
No,
in the
so
state.
therefore,
So
if
what
they
is-
have come up with a policy, if they don't
Lordship.
have the money, what is the state going to do?
Lordship, our only concern is that
They
The
should get
Ayushman
into
and the
who is
CMHIS.
paying for the central government? No central government. You see, without the central government, nothing can happen in this matter. And it is a fight. Your basic idea is that you should get the benefit of the Ayushman Bharat.
Lordship and the
Everywhere the
CMHIS.
central government is telling everywhere that we are giving benefit to everybody for 5 lakhs or not.
Yes.
So they should get the benefit.
Yes.
Now they are only the implementing agency. So they have to give it. Now if the state government has too much of money, which seems to be apparent, so they can very well give any other scheme. That's a different thing. And the fact that he wants money from him or him, we are not concerned. Isn't it? We're not concerned. So, you got a copy? File your affidavit.
This office copy, Lordship, officially they have to hand over one copy to me. This one.
That
I
is
have
what has been handed over to you.
I have received.
Because tomorrow you say that I am in Delhi,
Yes.
I am in Gauhati, so no copy was handed.
I have received, Lordship.
That is why Mr. Mojo has sacrificed his copy to you.
Yes.
And Mr. Mojo will take up this
I
copy
have an
because
extra copy.
it seems the PIL is at the behest of the
No,
state.
no.
Chalo. I'm not extending the interim order, considering the
Because
question
now
does
it
not
has gone to
arise.
transport. It has gone to transport.
No, I cannot direct them, the respondent number 6 to agree with anything. The Nagaland Private Doctors Association, how is it possible? You're issuing a writ against them. I've understood that these private hospitals were set up by lands by the government. It's a different thing. We can very well ask, but otherwise,
Sure.
in view of more particularly the recent judgment of the Supreme Court in the 7 judges, we have a right of property. That the judgment which went against the Chinaya judgment, that as regards right to property. The question arose out there, is that the right, and I think this is regard Article 39, 38, 38, I suppose. Article 38, the judgment came. So we cannot say that it is their private property. How can we enforce upon them they keep on giving service? If the state has anything, then we can. But anyways, I won't extend it. Mr. So-and-so appearing on behalf of the respondent number 5 submits that he has received a copy of the PIL petition, the PIL, and would like to file an affidavit in that regard. First, we have duly heard the learned counsels appearing on behalf of the parties. The case of the petitioner herein, is that on 15th of February 2025, an announcement was made by the government of Nagaland.
Lordship, the Nagaland Private Doctors Association, which is the respondent number 6.
Announcement was made by the respondent number 6 that they would not be providing further facilities in terms with the Ayushman Bharat
Stroke CMHIS.
oblique CMSIS. It is under such it is under such circumstances the present proceedings was filed. This court have also taken note of the submission of Mr. N. Mujoy and Mr. J. Seki, the learned counsels appearing on behalf of the respondent number 4 and 6. From hearing the learned counsels, it appears that the state government of Nagaland had appears that the state of Nagaland had come up with a scheme as regards the medical facilities to be provided to the people of Nagaland. Cashless facilities to be provided to the people of Nagaland. And in that regard, had entered into an agreement with the respondent number 5.
Lordship, it was an open tender, national tender. They participated and they were selected.
Now you have an agreement.
Yes, after that,
Had entered into an agreement with the respondent number 5 pursuant to an open tender process. It is the case of the state government that they have paid 100% of the premiums, but the respondent number 5 have not honored the claims of the respondent number 6, and it is under such circumstances the respondent number 6 have issued the said public notice. Mr. J. Saki, the learned counsel appearing on behalf of the respondent number 6 further submits that the as the respondent number 6, the private doctors who are members of the respondent number 6 are providing providing
Services under the state scheme.
service. They are required to be paid for their services, which have not been honored either by the state government or by the respondent number 5. First, from the above, it therefore appears that the dispute involved in the instant PIL, public interest litigation, is primarily a dispute between the state government with the respondent number 5, for which the respondent number 6 is not willing to provide their service. First, it has also been brought to the attention of the court that the state government now contemplating for issuance of a fresh tender and to enter into fresh contract for providing cashless facilities. And a contract between the state government and the respondent number 5.
No, not.
6.
Yes, yes.
Respondent number 5 had also ceased to operate with effect from
Correct.
1st of April 2025.
Yes.
First. Taking into account the above, the question of extension of the interim order does not arise in the present facts. First, it is observed that the pendency of the PL shall not affect the rights of the state government or the even to initiate such proceedings as permissible under law against the respondent number 5. The respondent number 6 can also pursue its remedies against the state government as well as the respondent number 5 is so advised.
The trust mode can be reflected law because
Which?
because we have now started the trust mode from 1st April. The payment will be made by the state government to the hospital if they provide service for 1 month till the new tender process. So if that maybe
You want that?
because that has been
Just before parting, this court also finds it relevant to observe that Mr. Mojoi, the learned counsel appearing on behalf of the state, respondent number 4 submits that till an alternative arrangement is made by the state government, made after floating necessary by entering into necessary contract agreements, the state government would be
we have already started.
and would be making due payment against any services provided by the respondent number 6.
Yes, through trust mode.
Through
Trust mode. TRUST trust mode.
to transfer
Trust mode. Trust.
through trust mode. Well, taking into account the above order passed in the PL, nothing further remains in I number so and so for which the I stands closed.
Actually, any date may be fixed for filing of our affidavit in opposition.
Okay, the next day, taking into account the matter in its entirety, this court fixes this matter on 8th of May, 7th of May 2025. Full stop. The affidavit be filed by the respondent number 5 on or before 25th of April 2025.
30 April. 30 April, before 30 April will file and 7th of May it will be listed.
29th 29th April 2025. The other parties to the instant PI would be at liberty to file reply.
I'm grateful, Lordship.
For orders, item number 10.
The appellation, Lordship,
Yes, what is this?
it is a contempt. Your Lordship, here in this contempt, the state has already complied with. But Your Lordship, here, by the notification 23rd January 2025.
What is this matter of contempt? Contempt for what? Oh, I have taken it earlier.
Yes. Now it has come to an end.
End?
Yes, but Lordship, by the notification dated 23 January 2025, the government has handed over 211 district court employee to the administrative control of the Gauhati High Court. So out of 211, I need to rectify some lists. So I may be allowed 1 week, and the matter will be listed on 9 of this month, next week. Only for the rectification only. In order to avoid any complication. Otherwise, the entire thing is already compliant.
Lordship, in the last occasion, out of 211 employees, they have handed over the service book of the rest, and 19 not handed over to the High Court. That's why they took time. This honorable court.
No, they say that they have already handed over 192.
Yeah,
What?
19
Yes,
19
that
days.
is it. And we are waiting for that.
then we'll rectify, and by the next step, we'll rectify and complete the job.
In the
Okay.
meantime, I have one prayer, Lordship.
Please.
Because of this contempt pending, a widow of one of the employee has filed writ petition number 21, 2024 before this honorable court. Her husband died in 2022.
Madam, I know, I wanted to tag along that repetition with this. You detect it. I remember that
Yes,
when this contempt came up before me, at one
Yes,
point,
yes.
I tagged this
Lodge,
matter
exactly.
along with that. Then
Exactly.
you made a prayer to detag it and it has gone. Now you are going to want to tag it?
one aspect, Lordship, tomorrow if that, because of this, Lordship, the respondent has already issued this to, on 31st, 1, 2025, already handed over. And because of this letter, 4th March 2025, Lordship, her case can be disposed of and her pensionary
Benefit is there, but why should I do it now? In this matter, do you have already detect that you are concerned only with these 19 employees now,
Yes.
isn't it? Okay, Mr. I inform the learned counsel appearing on behalf of the respondent submits that already 192 employees have, the personnel files of the service books of 192 employees have already been handed over to the Gauhati High Court to serve. However, as regards the 19 employees of the district court, the same the process is going on
Yes.
and would be handed over within within a day or so. So he therefore requested the matter be listed again on 9th of April for an update. So list accordingly on 9/3/4/2025.
Lordship, in the cost list, the name will be changed, name of the respondent council. In the
Okay,
cost list.
the registry shall also indicate the name of Mr. I.M. Song, the additional Advocate General of Nagaland, as the counsel appearing on behalf of the respondents.
Just one, one submission, Lordship. This writ petition was placed after the disposal of the contempt. That the order was passed on which date?
Contempt has not been
On
disposed.
12/11/2020. No, tomorrow before the single bench. It has already.
There tomorrow. It is listed tomorrow.
Yes, Lordship, so that in view of the passing
We'll
of.
see when the matter is there tomorrow.
Lordship, after the disposal of the contempt, this writ petition has to be listed. That is what was passed on 12/11/24 and placed under this contempt. However, because of 4th March 2024,
Tomorrow is the matter listed, the writ petition listed or not,
not, but I'm praying before this honorable court. That's
to list it tomorrow.
yes, Lordship. Single bench.
So why have you mentioned it now? Tomorrow you mention it. Tomorrow you mention it. I'm there, I'll take it over,
Lordship,
inform him. Let's see what happens.
Lordship,
We'll take it as unlisted tomorrow.
Lordship, obliged, Lordship.
For orders, item numbers 11 and 12.
Yes, what is this?
Lordships, this IA is filed for praying for continuation of delay of 165 days in filing the writ appeal. Lordship.
Yes. Commission, you have objection?
No.
This is heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant and Mr. So-and-so appearing on behalf of the respondents. All the respondents?
Yes.
This is an application filed under Section 5 of the Limitation Act 1963 for condoning the delay of 165 days in filing the accompanying writ appeal against the judgment and order dated 28/8/2024, passed in WPC number 206/2022. The counsel appearing on behalf of the respondent, Mr. So-and-so, submits that taking into account the grounds which have been mentioned, the respondents would not object to the instant application. This court further also have taken note of the grounds which have been assigned in the application, more particularly at paragraph number 6, 7, and 8, and is of the opinion that the said grounds constitute a sufficient cause within the meaning of Section 5 of the Limitation Act 1963. Considering the above, this court condones the delay of 165 days in filing the writ appeal against the judgment and order dated 28/8/2024, passed in WPC number 206 of 2022. Taking it in the interlocutory application stands allowed. List and put it out there. So taking in view of the above order, pass thereby delay being condoned, the list the writ appeal for admission next week.
Obliged.
For orders, item number 13.
May I please, your lordship, my lord, I'm mentioning on behalf of Ms. Sokre, additional agent. My lord,
Why? I saw her in the morning.
yes, due to some personal difficulties, she was compelled to leave the court at the earliest, my lord. So, my lord, she requested your lordship to list the matter on next week.
Lordship, I appeared for the writ petitioners before the single bench, Lordship. I have received a copy of the.
You received?
Yes, Lordship. And Lordship, I have also informed the clients, Lordship. They told me that they'll make an effort to travel this Saturday, Lordship, so that they'll sign the Wakala.
So we have to issue notice to you. Don't you think so?
Let me file my Wakala, Lordship.
No, whatever may be.
Lordship,
I have to
Lordship.
issue notice.
Lordship, Lordship.
Without issuing notice, how do I condone?
Lordship.
Unless you accept that I can condone. Can I condone you? That is why I saw your face. Okay, issue notice, making it returnable on 23rd of April 2025. Mr. Sentianger, the learned counsel appearing on behalf of the respondent, accepts notice on behalf of the respondent learned counsel who appears on behalf of the respondent number 1 accepts notice. In so-and-so, who appears on behalf of the respondent number 2, also accepts notice. Mr. Santiago, the counsel, submits that he would like to file an affidavit. Now, he would obtain instruction as to whether the respondent would like to, respondent number 1 would like to file an affidavit opposing the application for condonation. List the matter, list accordingly. In the meantime, the affidavit be filed.
My lord, similar prayer for number 14, 15.
Same order.
Yes, Lordship.
Yes.
Item 15 as well, Lordship.
Okay. You're paying for everybody. So just put down the registry shall show the name of their persons. And the council is appearing for respondent number 1 and 2.
Chief, I'm appearing on behalf of my senior Doshashiki.
Where is Jososeke? He's not there. So if he's not there, we should not
Lordship
say.
is the standing counsel.
Huh?
Standing
Just
counsel.
2 minutes before he was there, and he could not wait. So no name of her name. Not Jososeke. So finish. List.
Much obliged.
For hearing, item number 18.
Somebody sought for an adjournment. 18.
May I please, your lordship?
Ah,
My lord, I created this matter may be listed after 2 weeks.
oh, this one.
The opinion.
Counsel appearing on behalf of the appellant submits that a matter be listed after 2 weeks. Taking into account the above, is the matter on 14th of May 2025.
Obliged.
Anything else?
For hearing, item numbers 19 and 20.
My lord, this morning all the parties were present. This morning all the parties were present.
Then they are not used to sit waiting in the court till 4:15. Isn't the court timing till 4:45?
Yes, 4:30.
4:45? No, 4:30 or 4:45? 4:45, no? 4:45. Yes, you'll be arguing? Who is arguing? Shalom. None appears on behalf of the appellant. Who's the respondent, however.
May I please, Your Lordship, my lord, appellant is coming.
Where is she?
He's coming.
Okay, call the next matter. What else? Yes. What is the matter about?
Your Worship, in this case, Worship, in persons to advertisement issued by the state respondent. A selection was conducted. And Worship, the selection committee, they have recommended the name of the person appellant as serial number 2. And the private respondent number 1 is serial number 1. Worship, I challenge the recommendation of the private respondent number 4. On the ground that she is not an indigenous inhabitant of the state of Nagaland.
Then?
Well, Worship, but the impugned judgment in order. The learned single judge has dismissed my writ petition on the ground that since I participated in the selection process, now I cannot turn around and challenge the.
You are who? Who are you?
Worship, I'm the select in the select case, I'm the serial number 2.
You are the respondent.
No, I'm
In the-
I'm the appellant here.
No, then.
In the writ petition, I was a writ petition.
You're the writ petitioner.
Yes.
Then what order is passed?
Worship, the single judge has dismissed my writ petition
Huh.
on the ground that since I participated in the selection process.
Which order? Pusili. That one?
Yes, sir.
4/3/2022.
Worship, the impugned order is at page number 85.
85. 87 it starts, huh?
It's not from 87.
So what is the order?
If the operative portion is from start from page number 94. The paragraph,
Page number?
page 94 paragraph.
Question is to whether responsible for is indigenous provided verification.
By the impugned judgment in order, 2 writ petitions for disposal. By the impugned judgment in order, 2 writ petitions for disposal. My writ petition was dismissed. And the other writ petition, which was filed by the private respondent, during the pendency of my writ petition, the state respondent cancelled the indigenous, civil tribe and indigenous certificate of the private respondent. So we have
And
challenged.
what is the other writ petition? What order is being passed?
Worship, in the other writ petition.
Considering the important issue raised in the present writ petition as to whether the petitioner is an Emmanuel to score teams proper to direct so and so to verify as to whether so and so qualifies the condition to be the Iman as spelled out issue there and also as a season web. All reasonable options will be given and here shall be read. All the statements of the Indigenous Council shall be recorded in writing.
Correction passing the writ petition paragraph 25, page 110.
What is this judgment? State of Nagaland versus Nila to Supru?
Worship, yes, Worship, the private respondent, you're relying on this case, which was passed in the year 1990. But the principle laid down in the case is not applicable in the present.
No, only thing is, we are not concerned to that. He participated, he doesn't want to be first. He must sign the selection procedure. But it's a- Here we are, list one. And within 6 months, it is to. Yes, you see, your petition has been rejected on the ground that you have participated in the selection procedure. And therefore you cannot challenge the selection.
Yes, sir.
Which apparently we are of the opinion that was not right.
That is not right.
Taking into account that when you have participated, you did not challenge the selection
Selection process
procedure.
and challenge. No.
What you challenge that you have taken somebody on record or brought somebody within the zone of consideration who is
not
not
qualified.
an indigenous.
Yes, sir.
So that is it. But at the end of the day, if you see, that is a question of fact as to whether he is an indigenous or not. So the court have directed the deputy commissioner to look into that aspect. Now, has the court done anything? The deputy commissioner,
In compliance with direction passed by the regional single charge, inquiry was conducted.
then
Inquiry was conducted and the state government found out that she's not the indigenous inhabitant of Nagaland.
then what are you doing?
Now they have again challenged that order again in the next week petition, item number 20.
They are challenging
They are
that.
challenging.
How can we entertain that? Means isn't it a question of fact?
Worship, but during the inquiry, she was worship, it is like this. In order to qualify as an indigenous inhabitant of Nagaland, the state government has laid on a guideline in the year 1977. As per the office memorandum of the state government, you have to qualify 3 conditions. During the inquiry, she was allowed to produce the documents as per the guideline of 1977. She has submitted a representation.
So your writ appeal has been allowed.
It has been allowed since the.
No. So your writ appeal, what is your grievance in the writ petition?
Lordship, I have not filed a writ petition. The writ petition was filed by them.
So if we decide his writ petition, has he filed a writ petition?
Yes, Your
Writ
Lordship.
petition.
Yes.
If we decide the writ petition against him, your writ appeal is automatically allowed. So he's the main person. Don't you think so?
If he's qualified for a woman, as per the select list. In the select list, I'm at serial number 2.
Huh?
In the select list.
But once the select list is over, is over. You can't be appointed. There has to be a fresh election, isn't it? If it is a wrongly person, the wrong person has been appointed,
Yes, ma'am.
selection can be set aside. The question of that other person will be appointed doesn't arise. Can he be appointed?
My lord,
How do you do it?
no, my lord, as per the judgment passed by the honorable single bench, my lord, direction was given to the state respondent to conduct the verification.
No. I'm
So, my
not
lord-
done that. Now the state government has verified
Yes, my
and
lord.
found that the respondent
Yes,
is not indigenous.
yes, my lord.
So therefore his appointment will go.
Yes,
Now, because of the appointment will go, it will go for a fresh selection. Isn't it a fresh selection or he will be given the appointment? No,
first
it has
selection.
to
will
go
be-
for a fresh selection. This is how it is. So if it is a fresh selection, it goes. Then in that regard, what has happened, he is going to take care of it. Now, therefore, the question is whether his petition can be at all entertained. If he cannot make out a case that he's an indigenous case, inhabitant, matter is over. You dismiss him. And thereafter, the next consequences will follow, isn't it? What do you say?
In the select list, I'm at serial number 2.
So
When
what?
the select list number 1 is
But
disqualified.
select list is over.
If the select list, the pendency of the select list, it occurs during the pendency of the repetition.
No, but the select list, where is it that the waitlist candidate can be appointed? There has to be a fresh selection. But
But
while going for a fresh selection, your age will be condoned, that's all.
that's all, but regular selection was conducted. Regular selection was conducted. Persons to an advertisement. So
What rigorous selection for a post of sweeper?
no, Lordship.
Huh?
No, advertisement was issued. Advertisement was issued. Pursuant to an advertisement, we submitted our respective candidature.
Show me a Supreme Court judgment on this point. That person, after being selected, after the select list is set aside, then this court can direct that you should be appointed. Show me.
Nixon.
Supreme Court judgment.
Then
But I don't
Nixon.
think- Because in my opinion, it cannot happen. Because that will have a far-reaching consequences.
Lordship. Being at serial number 2 in the select list, when the select list number 1 is disqualified, I also acquit the right.
So. And you, what is your case? You are an indigenous.
In that respect, the state respondent had filed one affidavit in that respect, stating that the select list will be only valid for 6 months, if I'm not mistaken, your lordship. Even the state respondents had mentioned that in that affidavit.
Why are we on to that? First, tell
Lordship.
me.
For my
What about
case, your
this
lordship,
case?
for my
First,
case,
if you are not an indigenous, your job goes. And that has.
an inquiry
already
has been
found.
conducted, and I'm challenging the inquiry process.
Why? Means what is your reason for
The
it?
grounds is that no fair chance was given to me while the inquiry was being conducted. The process of inquiry was conducted in such manner that I was not
Affidavit has
given
been
ample
filed by the
opportunity.
government? You filed the affidavit in his writ petition?
In the writ petition, yes, my lord, we have filed one.
What is your reply to the allegation that you did not give any chance?
No,
That is
my lord,
to
we have given opportunity to the petitioner to submit the relevant documents. Claiming that since she is claiming that she is the indigenous person, so relevant documents was to produce before the authority. However, they have not produced. She has not
In that
produced.
regard, she have submitted a private respondent, she has submitted a representation, admitting specifically that as per the 1977 notification, she is not in a position to submit the documents. So, basing on that, the state government, they have cancelled her indigenous event. She has to qualify the three conditions, which has been laid down in the 1977 notification, which she feel don't fulfill that.
She failed
That
to
she has admitted in her presentation.
fulfill the 1977 notification.
Yes.
That was the argument of the petitioner during the time of hearing of read petition also. But
Where is the 77 notification?
We come to page number 46 in my read appeal.
Read appeal.
Read appeal. Page number 46.
That in order to qualify as an indigenous inhabitant of the state of Nagaland for the purpose of employment and individuals in the issuance of persons should have permanently settled permanently in Nagaland prior to enrollment. The following persons shall be criteria for enrollment. His or her parents of India was then minor. A minor should have been entered in the electoral roll of enrollment or the person should have been paying house tax prior to enrollment. Now, do you have a certificate from the Deputy Commissioner?
yes, your lordship.
And has that certificate been cancelled?
That was cancelled and we challenged that cancellation of the certificate by filing a writ petition. And that writ petition.
That
was
is the
allowed.
challenge in the second the writ petition.
In the first writ petition, your lordship. They filed the writ appellant filed a writ petition, and during the pendency of the matter, our indigenous certificate and scheduled caste certificate was cancelled. And then we challenged that by filing a writ petition. and our petition was allowed, Your Lordship.
Was allowed.
Yes, Your Lordship.
An appeal filed there against.
An appeal has been,
By allowing to conduct
Oh,
an inquiry.
this is appeal.
No, Lordship, in the first writ petition, that was allowed by directing the state respondent to conduct a fresh inquiry.
Understood. After that, what has happened?
after that, inquiry was conducted, but in
He
the
can subsequently cancel her indigenous independence.
in the judgment, specific direction has been given to conduct inquiry in certain process, and those has not been abided during the time of inquiry.
So that is,
for that
so
reason,
that
we
is
have-
the second writ petition.
Yes, we have filed a writ petition.
Where is the
alleging that
second writ
inquiry.
petition number?
I didn't know.
Item number?
I didn't do.
Writ petition number 296 of 22.
So what is your allegation? You were given a notice,
Notice was given.
huh?
Yes, Lordship.
You were given notice.
Lordship.
What is the English translation? This is. Where's the notice to you?
Become the page number 64 in the writ petition.
Page
64 in the writ petition.
Annexure 2 of your Lordship.
64. In compliance to the directives of environment, therefore the undersigned you are requested to attend the meeting without fail. Okay, so you are being given. You are also asked. Then what happened? Objection to the inquiry meeting conducted on so and so without offering none to be heard. What? Did you participate there or not?
Yes, Your Lordship. But we were not informed whether this was inquiry or not. We were just served a notice to appear for a meeting.
Then what happened?
Lordship, and certain individuals were summoned in this meeting. However, we were not given sufficient opportunity to present our case by.
Lordship, become the page number
Whether
10.
you had the three requirements, whether did you fulfill the three requirements, that's all. Do you have, did you fulfill? Because you require these three documents
Lordship.
to get a citizenship certificate.
Your Lordship, in the writ petition also, the ground where the writ appellate relied during the writ petition was on this notification 1977. But the judgment was passed in our favor basing on the judgment that we relied, which is Nilatio versus State of Nagaland, which is reflected in the judgment also.
What
And
does it say?
and the direction was also given in such a way that inquiry should be conducted, keeping in mind in that judgment, Your Lordship.
Now, what does that judgment say?
That judgment, no reflection has been made
Lordship, it's
regarding
reported
1977, Your Lordship.
1998, 112 GLD, page 112.
What does it say?
Well, Lordship, here the issue is totally different. Here the
No, what was the?
1977
direction passed?
notification was not
No,
relied in
no,
other
No, let
circumstances.
us say the judgment of 1998.
1998, Lordship. 1998, 112 GLD, page 112. Lordship, the issue is totally different. Here, in this case, Lordship, there's no dispute that the petitioner, she was an indigenous independent of Thailand. And here the challenge was which was against the Nagaland Technical Profession Degree Courses, selection of category rules 1995. She was placed as category number P. She was claiming for category A. That was the issue.
No, did the judgment of Justice Sema,
Your
the
Lordship.
single judge, say that the notification of 77 is not required to be followed?
Not this.
That has not been specifically mentioned, but we relied on this judgment stating that even in other circumstances, indigenous inhabitant can be recognized, Your Lordship.
Where?
We relied on two judgment, Your Lordship.
No, how, where?
Lordship, if you kindly read the paragraph 1, 4, and 5. Lordship, the facts and issues are here. It's clearly stated in paragraph 1, 4, and 5.
Yeah, in paragraph 4, this person concerned, his father has already paid.
There's no dispute.
So
But
therefore,
she's an indigenous.
he fulfills one of the conditions of the 77
Lordship,
notification.
as per this 1995 rules, here, candidate has to be considered under two categories, category E and category B. That means category E falls for indigenous, and for category B, category B for non-local candidate. Petitioner, she was put under category B, so she was filed the writ petition, praying that she should be placed under category E. That was the issue. In that case, there's no dispute about her indigenous inhabitant.
And that was considered, Your Lordship.
Admittedly, she was an indigenous inhabitant.
No. Does this court, in this judgment, does it say that you don't need to follow the 77?
No, it's
There has not been specifically mentioned, but direction has been given to rely on this.
Understood. You can rely on this, but here in this
Here-
case.
here, Your Lordship.
Mr. Counsel, kindly appreciate. Paragraph 4 shows that the petitioner's father was there in Srinagar in 1956. In 1958, he came to Kohima and became a member of some council and was paying the house tax to the Kohima municipality. So this means that the petitioner's father was an indigenous in terms with the 77 Act. So notification.
Your Lordship, our claim is also that we have arrived to Lazami village prior to 1977. That is our claim, Your Lordship.
1977 won't do 63.
1963, Your Lordship, yes.
So did you prove that?
Your Lordship, during the inquiry,
So did you have those 3 documents?
there are no documents, but
Then-
there are oral.
Oral is, how
Testament.
can you do? The 70, you have to challenge the 77
Your
notification.
Lordship, in this case, 1998 case, 77 notification was not dispositive. Here, the only issue was, she was claiming for placement under category A. Since she was placed under category B.
That was not the issue there.
Lordship, no, this judgment is totally misplaced, which they are like. It's not applicable in this.
So what as you say that the principles of natural justice was not followed by giving you an opportunity.
Your Lordship, we
So
rely
you
on
have
the.
approached this court.
Your Lordship, we kindly come to page number 77 in the writ petition. This is an inquiry report. Page 77 in the writ petition.
Yes.
Your Lordship, we kindly come to the last paragraph, second last paragraph. Letter was received from somebody so and so. That is a respondent for on so
The
and so.
order from a letter was sent to the village council and so to verify the authenticity of the claims of women and indigenous of the state and to submit the report. Were duly received by the office. Again on circular issued to convene a meeting on Maya wherein the statements of members were recorded in the meeting. In the meeting, course of the meeting, the contents of the government notification. It was made clear to all present so was asked to produce any of the document as stated. Requested for more time to produce the wherein a period of another 14 days was granted. Then
Lordship, as well, last paragraph. Letter was received from Mr. somebody so and so on
where's
27.
the finding? Where's the findings?
Lordship, on the basis of this, the
And
state
the office of
government,
the area agreed to grant so and so another 14 days. So yeah, the meeting ended with thanks. Now where's the order?
Lordship, we come to page number 91. This is the findings given by the state government.
Directed to refer to demand the matter regarding verification of area in respect to so and so have been examined by the area grounds and I can build the basis on the verification report with those confident. This one,
Lordship, this comment was given by the state government on the basis of the inquiry report furnished by the EDC Bogobudu.
but the question is, where is the finding?
Lordship, the conclusion, second last paragraph. During the inquiry, she has submitted a representation, admitting that she could not submit the documents which has been prescribed under 1977 regulation.
All understood. Where is the order? This person is supposed to pass an order. On the basis of whatever is there, what does he say? It is conveyed that based on the verification report submitted by so and so is not a year, meaning thereby On the basis of the verification report, you have decided, not on what he has stated.
Lordship, that's why, Lordship, in the verification report.
We are not concerned.
They have relied on a representation submitted by her.
This is given by the AR branch.
Year branch, Lordship. In the inquiry report is page number 77.
Conveyed the basis on the AR submitted by the ADC. Okay, ADC is where is the verification report?
Page 77.
70?
77.
70?
77.
Where is the verification report?
Lordship, this is a verification report.
No, what does it say? Where is the finding?
Lordship, we come to the second last line. Our leader was received from Selimari so and so. Lordship, got it? Page 77. Second last paragraph. Our leader was received from Selimari so and so on 27 July 22. Wherein it is stated that the documents as prescribed in the government notification number so and so dated 28 April 77 cannot be produced. That she has submitted para it.
But where is the finding?
Lordship, no finding.
So if there is no finding, where is the report?
Lordship, this is submitted for your kind information and necessary action, please. No, she has forwarded to the state government.
Mr. Counsel, at the end of the day.
No finding, Lordship. No finding.
You see whose direction it was? Who was to decide? That direction was given to the ADC.
To conduct the inquiry.
Pugubotu. Now, ADC Pugubotu was supposed to therefore pass an order saying that he is or not. Where is that order?
Yes, Lordship. That is not here, but
No, my lord, your question may kindly see page number 74, the final order.
Of the writ petition.
Yes. Page number 74.
No, this is done by the DC.
No, by the ADC.
This comes from here.
My lord,
No, Mr. Counsel.
on the basis of the approval complete by the state government.
Yes, no, what has happened is this. This is the manner in which it has been done. When we see this particular order, when is the disease order? Yes. With the disease order, I've seen it earlier. Yeah. This one. Kindly see page 91. Where is this order of 24th of August 2022? Where is that?
24th August 22.
Where is that?
Lordship, it's not on record.
This is the main order on the basis of which these orders are being passed. No, what to do?
Your lordship, during the hearing of the writ petition, we relied on another citation, your lordship, which is Anjan Kumar. Their defense circumstances were considered for considering the indigenous.
Anjan Kumar is on a different pedestal. This was a case about that particular, it was a case of scheduled tribe. A
Yes.
person who comes over from another place and was there with the
Yes.
mother.
Yes,
So that was a case of Anjan Kumar, which is, Anjan Kumar is by Justice Sema's judgment, isn't it?
yes, your lordship. We are all also placed in the same situation, your
The
lordship.
Bogopuri is just nearby, so on next.
How does Anjan Kumar come into the field out here? Anjan Kumar is on a different pedestal altogether.
For considering a person to be an indigenous person, your lordship, other circumstances.
Anjan Kumar is not for indigenous. Anjan Kumar is as to
Yes.
whether he will be a scheduled tribe,
Scheduled tribe,
taking
yes,
into
your
account
lordship.
that his mother was the scheduled tribe and the father was not.
Lordship.
Subsequently, there is another judgment being passed by the Supreme Court. Anjan Kumar was there of the 2-3 judgment, and the latest one is of the 2012. What a day.
Facts and show totally different. Here in the admittedly the state government, you have framed the 1977 notification. That's who goes for this one.
No, but where is 24th of August 2022?
The London government,
My lord,
state
that,
council maybe.
That is the document.
yes, my lord, that letter is not in the record.
That is the most pertinent document we have not brought. And without that document, he has a case.
In that case, next witness. Next witness.
He has a case without that document.
What is the content of that?
Because you have only put excerpts of that 24/8/2022 in all these places.
My lord,
Anyways, what to do? Well, here, you can get it on Friday.
no, my lord, next week, my lord.
Next week, the matter
Next
is over then. Nothing can be with it. You had a case, both of you. Nothing can be happening.
You should go next week. Buku is just nearby. Buku is just nearby.
We want you can get it by fax or whatever may be that order.
Wednesday, my lord.
If you-
Next Wednesday, my lord, 9th.
Okay, chalo. But this won't happen again. Okay. Because I can't, me and my brother are sitting, so there
Next
might be a
week?
change in the bench next week.
Monday.
Monday, there'll be a change of the bench, most likely. We won't be there,
Next Monday.
so it won't be possible. Chalo. As the meeting, the hearing remains incomplete, taking into account that the most vital document, which is the subject matter of petition number 296/2023 is not on record. Because the document in question is the document dated 24/8/2022, which is the basis on which subsequent orders have been passed. First, Mr. So-and-so appearing on behalf of the respondent state submits that she produced the say document on Wednesday. What is the next? 9th. List the matter on. Yes, what is that?
My lord, there is one more item left, 23 and 24. If that can come up next week, next Wednesday, 9.
You have objection? Okay, at the request of so-and-so, the matters be listed on 9th.
Your Lordship might be able to give us a partner.
I can't. The moment I make it part heard, if one of us is not there, this matter will get stagnant.
Your Lordship may target the list as a first hearing item.
I'm telling you, how is it possible? If my brother is sitting somewhere else, I'm sitting somewhere else. If I was here for, both of us were here for 2 weeks, it would have been different.
Okay.
We'll see on 9th, if both of us are sitting, we'll take it up.
Okay, I'll make a mention if necessary, if possible.